And I'll do the court cry. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court. We are your panel for this case and for the other cases that will be heard before us today. With me today, it is my great privilege to be sitting with my colleagues, Justices Milkey and Justice Shin. Although we are sitting in this format due to the ongoing pandemic, all the ordinary rules of oral argument apply, which include that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case Joseph Mazzocchia and others versus Keolis Commuter Services, case number 2020P1039. And we're ready whenever you are, Attorney Laporta.
May it please the court, Sean Laporta on behalf of Robert Mazzocchia, Joseph Mazzocchia, and Brenda Lewis, also known as the employees. I will assume familiarity with the facts of this case unless you have a compelling need for a summary. I don't want to waste the court's time on that. I'll get straight into my argument. There are at least a few outstanding questions that needed to be answered, which would have prevented Keolis from prevailing on their motion for summary judgment. Two of those questions are the reasons behind the punch order, as explained by the chief mechanical officer and decision maker, Mr. Turan, and also what was the reason for Turan's decision in terminating the plaintiffs. And the answer to these questions speak directly and are related to and are required to sustain Keolis's burden and step 2 of the McDonnell-Douglas burden shifting analysis in demonstrating a non-discriminatory reason for termination. And the reason that this is important is because an employer in the Massachusetts must not only give a reason that is lawful for the termination, but also must produce credible evidence that that reason was the reason for the termination. And support for that can be found at Blair versus Husky Injection Molding System at also Lewis Area 2 Home Care for Senior Citizens, as cited in my brief.
May I interrupt you for a moment? Did you take the deposition of Mr. Trahan?
We did not take the deposition of Mr. Turan.
Did you seek to?
We did. So we sought the deposition of Mr. Turan close to or after the discovery time period had elapsed. Prior to that, we had a pretty good relationship for extending those deadlines for these sorts of circumstances, but that was opposed and we weren't able to get the extension. Regardless of
the court to take that deposition late and the court denied that request?
That is my understanding. If it wasn't directly the request for the deposition, it was the request to extend the discovery deadline so that we could take the deposition.
So you did not timely seek his deposition and then the court denied the extension of time?
That is correct, Your Honor.
Okay. Well, in those circumstances, why is it that the defendant has an obligation to provide an affidavit from a deponent you chose not to depose?
Well, I think that there's a couple answers to that. And one of them is that it's the central issue here, is that after a plaintiff employees have sustained their burden of proving or demonstrating a prima facie case, is it then incumbent on the employer to submit positive testimonial evidence such as an affidavit or deposition testimony
right.
supporting.
I think we should be as accurate as we can with this. They did provide affidavits and documentary materials in connection with their summary judgment motion. They just did not produce an affidavit from this particular person.
That is correct. But the state of mind of the decision maker is a central issue in every employment decision, discrimination case. Not only is it, a central part that where the focus by the court and the trial level should be on the intent and the mindset of the decision maker, but the converse is true as well. You cannot support a case for discrimination based off of discriminatory acts by people that aren't the decision maker.
Do you have any court precedent to support your position that the employer per se had to submit an affidavit from the decision maker in this context?
I think that's a great question. And no, we have no specific case law that says that an affidavit is specifically required. We do have case law that specifically states that the state of mind of the decision maker is of utmost importance. And I would query how we can determine that situation, the state of mind of an individual, without an affidavit or some other testimonial evidence from that individual as to the state of mind. As you know, affidavits can only be submitted on a person's own knowledge. So even an affidavit from another person saying what another person did and the reasons that person did it, that's not enough to have to show whether or not a decision by that individual was made on any sort of belief.
Right. What is the normal articulation for the stage 2 burden?
The specific stage 2?
Just give it to me as verbatim as you can, the normal legal standard for stage 2.
Well, as I understand it, at stage 2, an employer must show a legitimate non-discriminatory reason for the termination or the adverse employment decision.
Right, and it's not show, it's articulate. It's articulate a legitimate reason supported by credible evidence.
Yes.
And it doesn't say anything about the individual decision maker's state of mind. And so part of me is wondering whether when you make this argument, you aren't in fact trying to import the question that arises in stage 3 having to do with pretext into stage 2.
I understand your concern there. And I think the arguments would be very similar at stage 3. Even if you were to find that the employer submitted credible evidence and that they passed into stage 2. The analysis isn't too much different for why we need to know the state of mind of the decision maker at stage 3.
Why is it there that you don't founder on the fact that you didn't depose Mr. Trahan?
Why is it not? Why does that not rest on us? Is your question?
I mean, you had an opportunity to, if you really wanted to know what Mr. Trahan might want to say or might have to say, and that's what discovery is for.
That is correct, Your Honor. And if in a perfect world, we would have been able to depose Mr. Trahan, but circumstances of the discovery process prohibited that. So we're left with how we can get through the stages as we have them. Again, I do think that the evidence submitted is not sufficient. I don't think that if we go back to the business records, or actually, let me pull back a little bit, and hopefully this can explain a little bit better. The decision-making process in its totality is being questioned here. It's not necessarily just the act of signing a termination letter. So we have Mr. Trahan. He was the one that initiated the punch audit. He was the one that told McNeamer, his subordinate, to do the audit, which at the end of the day was into a common act and practice at Keolis, which was badge swiping. So Trahan's state of mind on that very point of starting an audit that then purportedly was the reason for the termination, that is all very important to why did this occur? How did this happen? What was the real reason behind Trahan's motivation to do this? Especially when we put into question the affidavit, the text message that prompted McNeamer to bring forth this.
Well, what did you put into question that after there was the affidavit that attached the image of the text message? And again, here, I want to know whether that screenshot was produced in discovery.
I do apologize. I don't know if the screenshot was produced in discovery.
Requested?
I'm sorry?
Did you propound document requests?
We did, and they should have been encapsulated in discovery. I do not have any reason to believe it was not provided.
Okay. So, and all right, go ahead.
But regardless,
actually, can I just interject here? Could you explain to us the import of your argument about this being a common practice? It's something you emphasize in your brief, but I'm having a hard time understanding the relevance of that to the issues of discrimination.
Yeah. So it kind of opens up the box into a little bit further of an explanation. But the reason the common practice is important is because it was a common practice. In the decision by the lower court, they talk about how, well, these individuals, the employees, they were caught doing something. Well, they weren't caught doing anything. This was a normal practice. Everybody swiped in, everybody swiped each other's cards. There's deposition and affidavit testimony that accounts for this. This is put forward.
Why does that matter? Why does that matter? Let's just assume for a minute that they were stealing funds, and everyone was stealing funds.
Well, that's not the allegation, Your Honor.
Does that mean that an employer cannot terminate people if they are over age 40, no matter what they're doing?
Of course not, Your Honor. I mean, I think
so that's
very important distinction.
That's what I think is Justice Milkey's question. Is age a shield against termination for what looks like here cause?
Well, if it's not for pretext, there could be the illusion of cause, right? And I do want to point out that there's no that stealing or an illegal act is not at issue here. It's a common practice. It's disputed whether or not there was any time stealing, and I don't believe that actually was the issue here. It was swiping in each other's badges. Did that violate the code of conduct? And did that violation of the code of conduct create the issue of termination?
No, but can I just say the swiping practice creates the potential for time stealing, and enforcing the no double swiping, whatever you want to call it, is a way of preventing time stealing. So why should the employer have to prove that there's actual time stealing?
Well, I think we're pushing together a couple things at once. If you wouldn't mind, I'll try to answer your first question because I think that one's relevant to this situation. Otherwise, we're importing a little bit of our decision-making process into the decision-making process of a corporation, which is not at issue here. The issue is that the punch audit was 20 days. It's not even 3 weeks. We believe that because it's a common act and occurrence in policy for this time swiping, if that would have been a larger time period, you would have seen many, many more people doing these swipes. Yet I apologize.
So what?
Well, the only people that were terminated.
What required the company to do an audit for longer?
Nothing did. The issue isn't necessarily taking them each step by step and saying, did this occur? Okay, then we can move on. The question is put together. Did Turan investigating something that was a common act in practice, was that his pretext for then coming up with a policy violation that then he only applied to those people in the protected age group and terminated those individuals? So it's all connected to the beginning to the end.
What is your evidence in the summary judgment record that the decision to conduct this 20-day audit was a pretext, which I guess is where the rubber hits the road, so to speak?
Yeah, and I think that has a lot to do with our context for this being a common act in practice. What other reason would they have other than to have some other pretext? If it's always something that's done and no one is getting in trouble for this, and if the testimony and evidence submitted by our clients are to be credited, which it should. Otherwise, you're weighing evidence of one person's affidavit against another affidavit. And trial by affidavit is certainly not recommended or by the court system. Then if that is put in question, that entire process, that's kind of the part of the reason for why that's why it's important that it was a common practice. Because, and I use this analogy, and I know it's a little bit silly, but in my brief, is that if this were as simple as a dress code policy and you applied it inappropriately, you only allowed certain people to dress down, that would be discrimination if it was only against certain classes. So if men were able to wear shorts, but women couldn't wear similar styled skirts, that would possibly be an issue with discrimination.
So let me make sure I understand. What you're saying is the evidence you put forward on pretext is the fact that it was a common practice, everyone did it, and yet only these 9 people were faced employment consequences as a result of this limited audit.
That is at least in part what we've submitted as
What else
pretext.
did you have?
We've also have the comparators, which that we've submitted for Rosario and the other 2 individuals.
One of whom was over 40.
I believe 2 of them were over 40.
They weren't terminated, so they're not good. I mean, all right, we'll look at the record.
I'm sorry. Yeah, you're correct. Sorry, I had my numbers backwards. Yep.
Okay. I think we have your argument. Let me see if there are any other questions.
I had one question. If you did not have the comparators, would you still be arguing that there's sufficient evidence of pretext?
I believe so. I don't think, I mean, if we had smoking gun evidence, this whole thing, the burden shifting analysis wouldn't be required. So we're entitled to try to get that in however we can.
So without the comparators, your argument would be that somehow they timed this audit to target the 9 people who were seen on the video swiping the badges?
Well, I think that's a little bit of a reach that we're claiming that this was a specific target of a thing. I think sometimes things work out, but that the punch audit was only applied, or the discipline resulting from the punch audit was only applied to the people in the protected class. Does that answer your question? I'm sorry, maybe I misunderstood it slightly.
I'm assuming a situation where we don't have any comparators who are seen on the video violating the policy. So then it seems then that your argument would be that this audit was somehow designed to target people in the protected class. Wouldn't that be your argument then if you didn't have the comparators?
It certainly could be part of the argument. It could have been designed specifically for that purpose because it didn't encompass anybody. It could have been for timing that just works out. You find out that that time of year, certain people do certain practices. I don't have enough evidence here to elaborate more on that specific issue, but it doesn't matter as much to me why if it was a targeted audit. Just that the audit was into an act and occurrence that was common, that everybody did that act and occurrence. And just because it wasn't encompassed and we didn't get hundreds and hundreds of people in that specific time window that's very small, that isn't proof that this isn't a common act and occurrence. It's a 20-day snapshot in over the hundreds of collective years by these employees working at this facility.
Okay. Is there anything else from the judges? Thank you. We have your argument. Attorney Lunt? Attorney Lunt?
Yes, good morning, Your Honor. Good morning to the members of the panel. May it please the court, Thomas Lunt, on behalf of the defendant and appellee, Keolis Commuter Services, LLC. Your Honor, as part of the questions, you hit the nail on the head here. The appellants have misapprehended the burden shifting paradigm set forth in McDonnell Douglas and adopted by Massachusetts state courts. The lower court found that the plaintiffs here, the appellants here, had satisfied their prima facie case, which is not an odorous burden. The burden then shifted to Keolis to articulate a legitimate, non-discriminatory reason. That burden is a burden of production only and not a burden of persuasion, as the appellants inaccurately describe on page 26 of their brief. We submit, as the trial court found correctly, that Keolis satisfied that burden of production by demonstrating that it believed and it took adverse employment action against the appellants due to the falsification of time cards by swiping each other's identification cards through the Cronus time system. That production burden was met through the affidavit of the charging officer, who was substantially older than the appellants, who described the punch audit that he did over a 2-week period in which he identified the appellants. It was also satisfied by the affidavit of the hearing officer, who at the time was 66 years old, who oversaw and acted as the hearing officer for the formal investigation hearings to which the appellants were entitled under the collective bargaining agreement, and who concluded—
Counsel, how is it relevant that the hearing officer himself or herself was in the protected class?
It is relevant in the fact that this is an age discrimination case and that the participants on behalf of the company also were in the class, and therefore, as part of the allegations that the appellants have asserted, that the hearing officer is likely to be, there's case law that says that similarly situated individuals in the same class are likely to be the victims of discrimination and not the, those discriminating, if you will.
What do we do with the fact that, and I'm going to get the employee's name wrong, maybe Baker?
Scott Baker?
There's an affidavit submitted, if I have the right name, from Scott Baker, saying that he never sent a text to, is it Trahan? Saying he had having anything to do with a doctor's appointment or anything else. And that the claim is, though, that really what got the whole chain of events going was Trahan's noticing that Baker was logged into work at the same time he had sent a text claiming he was at a doctor's appointment. Why is that not a sufficient factual dispute to preclude summary judgment? Where, as I understand it, the plaintiff's argument is that there was some kind of discriminatory animus that triggered the 20-day audit.
Thank you, Your Honor. I believe you're referring to Scott Baker, who was one of the 9 individuals. And I believe you're referring to a text that Mr. McNeamer, who was the charging officer, testified to.
Yes, for the correct name.
Yep. And in opposition to the summary judgment, the appellant submitted an affidavit from Scott Baker indicating that, or purporting to state that he never sent the text. We submit that the text, as well as the nature or origin of the punch audit is immaterial here, given that the appellants have conceded that they participated in the actual conduct to which led to
I don't understand that argument, because let's say even if they do concede that they were doing the conduct, doesn't mean that the company's effort could not still be discriminatory if all they were doing was trying to find a group of 9 people over the age of 40 to fire.
I don't believe that was the intent of the punch audit itself. I mean,
But that's the question, is if it's a disputed issue of fact as to that text, then why doesn't that throw the intent behind the punch audit into question?
Why doesn't it throw the intent of the punch audit into question? Well, I believe that the records that Mr. McNeema testified to, that he had requested a meeting with Scott Baker. The record indicates that Scott Baker did not show for that meeting and was not at the Keolis facility. Whether or not there was a text to McNeema is just one part of the evidence to demonstrate that Baker was not available, yet still on the clock. So while there may be a dispute as to whether a text was sent, the other records indicate that 1, he did not attend a meeting, and 2, he was not at the facility based upon the eventual recordings found by Mr. McNeema.
I see. What you're saying is that even if the reason there was a dispute as to whether or not he claimed he had a doctor's appointment, there's no dispute that he was logged in when he wasn't at Keolis.
That's correct. And the dispute as to whether or not a text was sent is immaterial to that fact.
Could we also drill down specifically with regard to employee Rosario, because she is in a sense the best potential comparator for the plaintiffs, and the plaintiffs claim that there's a dispute of fact about whether there was a justification for giving her more lenient treatment. Why doesn't that dispute of fact raise enough of a material dispute for the plaintiffs to survive summary judgment?
Yes, that was a part of the argument, summary judgment. I believe the trial court spent a considerable amount of time in its decision in order addressing that. Let me step back. During one of the appellant's internal investigation hearing, Ms. Rosario's name was brought forward as somebody who also swept an identification card that was not hers. In order to be a comparator in this case, in a discrimination case, there has to be similarities in all major, under Matthews v. Ocean Spray, without any distinguishing facts. Here, Keolis accepted the identification of Ms. Rosario and did an independent investigation into that. And while it is true that she did swipe her sister's identification card, there was an investigation that distinguished her act from the acts of the appellants and the 6 other employees who eventually were terminated. One, Ms. Rosario provided an explanation that it was an inadvertent swipe of her sister as they commute to work together. Her sister was on video standing next to the Kronos time system, and she did say that it was by accident. Contrary, the appellants and the 6 other individuals do not appear anywhere in the video next to the Kronos time system, and appear to be concede that it was a deliberate act of swiping each other's card, thereby falsifying time records.
What I understand the video showing is that Rosario swiped 4 times, and then the video doesn't show her ever giving any card back to her sister. And the plaintiff's argument is that this puts Rosario's credibility in dispute, regardless of what was determined during the internal investigation. Why isn't that enough to go to the jury? Why can't the jury disbelieve her, Rosario, that this was inadvertent?
Yeah, I don't believe it's disputed that the Chronos time card system required at times multiple swipes of an ID card when the magnetic strip was worn down. So again, Ms. Rosario provided an explanation.
Why isn't the jury entitled not to believe her explanation? I mean, this is on summary judgment, and it seems as though the judge put a fairly onerous burden on the plaintiffs to provide evidence of pretext just to go to the jury. So why isn't this a credibility determination?
We don't believe that there was an onerous burden on the appellants to show pretext. And I guess I would just simply suggest that it wasn't a comparator because of the nature in which the company investigated. Appellants claimed that Rosario should have been somebody identified in the punch audit. She was only there once, and whereas the appellants and the other employees are appearing on the 2-week punch audit doing this numerous times, whereas Rosario is a one-off, where she provided clear explanation that it was inadvertent, that her sister—
Were the first swipes of the same card? Was that in the record? Was it in the record whether the 4 swipes were with the same card?
Yes.
They were all her sister's card 4 times in a row?
Yeah, on the video, you can see the 4 swipes in a row. Correct.
With the same card, which was her sister's?
That's correct. In which only registered 1 time entry.
Oh.
What about Roscoe, who the one of the affiants estimated to be in his early 30s, and then provided evidence later, which I know the judge didn't accept, that he was in fact in his 30s, and he was seen on the video swiping multiple times and was never disciplined.
Well, we would submit that would be inadmissible evidence. One, it was attached to a motion for consideration, and it was, a lack of foundation, lack of personal knowledge of a birth certificate. While a birth certificate,
someone can't estimate a person's age just from appearance. I mean, what if they estimated this person was, 18 years old? I mean, can't you tell the difference? Isn't it within common knowledge to tell the difference between an 18-year-old versus a 40-year-old?
I don't know. I mean, I think that when it comes to admissible evidence, one can speculate as to somebody's age, but in an age discrimination claim where your burden is to demonstrate that the company had a pretext of discrimination against older employees, I believe more is needed than just speculating or estimating as to what their age may be.
Let's say we were to disagree with that. Let's say we were to disagree with that.
Okay, then I would point to the actual record that was before the trial court at the summary judgment stage. Again, it was appellant's burden to demonstrate that the company's reason for termination was pretextual. Therefore, it was their burden through discovery to find comparators. Appellants, either through lack of due diligence in their own case, did not determine what the exact age of that alleged comparator was, and in an attempt to demonstrate at a summary judgment stage, simply put it in an affidavit speculating as to the age.
Let's say that we think that's enough. How would you distinguish Roscoe as a comparator?
Unfortunately, there's not enough evidence in the record for me to do that here.
So the affiant, this is Joseph Mazzocchia, he does have some direct knowledge of his person's ages because he was a union representative, right? So why is that not enough?
Again, he's still speculating as to what their age may be. One may look late 30s and be in the protected class over their 40s. Just because you interact with or potentially interact with another in your employment.
He's saying he represented some of these employees, so he knows their ages.
I'm not sure if the affidavit goes that far. I haven't looked back. That is not my recollection of what by representing someone you don't know the age. I'm not sure if that the affidavit. I'm sorry, I don't know the answer to that.
Counsel, just a fine point on the law. You said about a minute ago that at stage 3 of the test, the plaintiffs have to show pretext. Is that a real statement of law, or is it they have to show that the fact finder could find pretext?
I believe it's that they must demonstrate that a reasonable jury could find that the articulated reason was not the real reason for the adverse employment action.
All right. Thank you both for your arguments. It's an interesting case. We've been helped by your arguments, and we thank you for them. And with that, the case is submitted.
We thank you.
And we are back live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. The panel this morning for this case is Justice Milkey, Justice Shin, and myself, Gabrielle Woolahojan. We are conducting court in this format today due to the ongoing pandemic. But although we are doing so, all the ordinary rules of oral argument apply, just as though we were conducting court live. And that includes that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Philip Howard versus Richard Daynard, case number 2020P 0916. And Attorney Lamanna, we are ready whenever you are.
Thank you, judges. Good morning. May it please the court. My name is Jennifer Lamanna, and I represent the proposed intervener, Jennifer Howard. This appeal is before you because Jennifer Howard's motion to intervene pursuant to Rule 24 should have been allowed as of right, pursuant to Section A of that rule. We say that because Jennifer clearly claimed an interest related to the property that was at dispute in the underlying litigation. The underlying litigation involved a transaction involving Unit 2408 of a condominium complex that was purchased during her marriage to Philip Tim Howard. For clarification, I'll be referring to my client as Jennifer and to Mr. Howard as Tim, given that they have the same last name. So
I want to ask a couple of questions if you don't mind.
Certainly.
The interest that your client claims in the condominium is not like a title interest, right? Or an ownership interest, because she was not an owner of the property. Am I correct?
She was not a titled owner to the property. That is correct.
Well,
so
are you claiming she's some other kind of owner?
Yes, that she's an equitable owner to the property under Chapter 208, Section 34, and the case law interpreting that statute. So 208, Section 34. Is that
an equitable owner, or are you, I want to make sure I'm understanding things within a framework. I understand, which isn't necessarily correct. What I understand you to be saying is that the condominium was part of the marital estate, and therefore it was subject to property division as part of the divorce. And her interest was the interest that she had in the marital estate, of which this condo was a part. So it's not really an ownership, if that's correct.
Well, it depends on how you're defining ownership, Your Honor. So there are a couple of different cases that I cite to in my brief, Laura, Sella, and Rice, where the appeals court was grappling with what constitutes ownership in the context of a marital estate. And in division of a marital estate, the court's not bound by traditional principles of ownership, who has title. Anything owned by either party, and in Massachusetts, regardless of when it was acquired, can be considered part of the marital estate. This divorce is actually taking place in Florida, where Florida has a slightly narrower definition where they discuss the fact that the property is acquired during the marriage. There's no dispute that this property was acquired during the marriage. So she certainly has an interest in, as it's part of her marital estate, it is subject to division to her. And so based upon that.
Counsel, why isn't your client's claim, if at all, against the husband and the proceeds of the sale, as opposed to a right in an action involving ownership of the property?
The reason for that is because under the terms of the disputed settlement agreement, and when I say disputed, it was being disputed by Tim and Daynard. Under the terms of that, there were no proceeds. The entire property was going to Daynard. Any proceeds were basically subsumed with if anything, to be left over. It was minimal indeed. And of course, her husband was not adequately protecting the interest. He signed a stipulation on February 3rd, 2020, down in Florida, agreeing to protect the interest in the property, concealing the fact that he had signed a stipulation for it to be given away, essentially, to Daynard and to satisfy his personal debts. So there's no question that as of the time that Daynard sought to enforce what he considered to be the enforceable provisions of the settlement agreement, Tim was no longer, if he ever was, protecting the assets of the joint marital estate. So the only way that she could protect her right to division of that asset was by seeking to intervene and pursuing her own interest. Tim essentially abandoned the litigation.
Couldn't she get some kind of order from the Florida court, the divorce court, that would somehow stop the disposition of the condo in the Massachusetts action?
So could the Florida court have issued an injunction to halt the enforcement of the settlement in Massachusetts?
Or something. You see, I take it your argument is that that condominium was subject to the jurisdiction of a Florida court as part of the marital estate.
Yes, it certainly is. And although very often in divorce proceedings, people have resolutions as to property in a different state, have just that piece of the divorce resolved in that state. So whether or not the parties would proceed later in a Massachusetts probate and family court for the division of that is a separate question. But
could the Florida court have issued an order that said the declaring the condominium a part of the marital estate and saying that it cannot be transferred or alienated prior to the Florida court determining what should happen?
That's a very interesting question because I haven't explored very much. Certainly there's full faith and credit that would be entitled here. Any Florida order like that would be entitled to full faith and credit. But whether or not a Florida court would have the ability to enjoin Daynard, who was not a party to that Florida proceeding, from enforcing his interests, which is what he was trying to do in Massachusetts, is not something I've specifically explored.
At a minimum, your client could argue in the divorce proceeding that the husband dissipated assets, right?
She could certainly argue that. The problem with that.
So I think where I'm struggling is how your client's interests are not adequately represented in this lawsuit, because just because this property is part of the marital estate doesn't make their interests adverse.
You're absolutely correct. But what makes them adverse is the fact that Timothy Howard has halted any attempt to preserve these assets and signed a settlement agreement without disclosing the terms to my client, did not respond properly to the motion for summary judgment, My client
Right,
was
well, I mean,
prevented from
so I take it that you're saying there is inadequate representation because there's some sort of collusion. But the case law is clear that the burden is on your client to make a compelling showing of inadequate representation. And in the record, all I see is an assertion that there's collusion. So where is the compelling showing?
in terms of the compelling showing, so first we have the fact that this is not a married couple which is the Little Vielas case, where the couple was still married and the wife was trying to argue that she had interests that were separate from her husband's. This case is very different from that. These parties were divorcing. They were engaged in an active adversarial proceeding in Florida. The husband this was the husband's debt. This is the husband's former litigation partner.
I'm sorry to interrupt, but unless the husband and Daynard are colluding, I still don't see how the husband and wife's interests are adverse. And I don't see any evidence in this record of collusion.
And you may not, because collusion is something that is something my client could have developed had she been allowed to intervene in the proceeding. What she's alleged here is that her interest is not her interest in, at a minimum, 1/2 of that property. And of course, it's an equitable distribution. She could be found by the Florida court or Massachusetts court, regardless of who was making the property determination, to be wholly entitled to whatever interest the marital estate contains. Her husband, Tim, was no longer seeking to protect that asset from the marital estate. So her interest as a litigant in the divorce was to protect her share and her potential share in the marital assets. Tim had stopped doing that, and he was resolving his personal debt.
In the same vein, though, I'm having a hard time understanding the theory of a collusion here, in the sense of, if there are no sales proceeds, then you could be arguing one of three things. One is there was some other consideration that is being hidden. Another would be the husband has, notwithstanding the transfer, retained, in fact, control over the property. And a third might be, just out of sheer spite, the husband gave away an asset. So to what extent are you specifically arguing these theories? And is there any evidence in the record of any of them?
Well, respectfully, I don't know that at the motion to intervene stage, my client is required to have established a full discovery record about what the transactions between the parties were. But I would suggest a couple of different points that are reflected in the record, which is that when this case initially came before the court, the Middlesex Superior Court, the dispute was whether or not this option to purchase with a deed was a sale or a loan. Tim alleged it was a sale, something he had done with a former business partner many times. There was no intention to divest him of title, etc., and that this was merely a means to an end to basically conceal an usurious interest rate. Daynard strenuously objected to that and said, no, this was a sale. So whether or not there was collusion on that point, and the Middlesex Superior Court addressed that, Judge Ricciuti commented on it a couple of different times. He wondered if the court was being asked to enforce something that was against public policy. So there is a suggestion in the record and reflected in the appendix that the lower court judge was concerned that what this original transaction was, the one that my client didn't know about and was not shared with her, was in fact a collusion between Daynard and Tim to conceal an usurious rate of interest, which is 100% within 5 months. So there is certainly that suggestion of collusion. Whether or not there is spite, I think the court, I don't know that I have to prove spite at the motion to intervene stage, but Timothy Howard entering into a stipulation on February 3rd, 2020, saying, I will take all steps necessary to protect the property, preserve it for the marital estate, and do all of these things, and then doing nothing, could be evidence of spite. It could simply be that he had cut some other deal. And that's the concern here. Now, my client may be simply a suspicious wife in a contested divorce, but her suspicion is that Timothy would never he's a savvy tobacco litigator, an highly intelligent man, and an experienced attorney, that he would never have allowed this to go this way unless he was getting something back from the transaction, something more than the end of the litigation. So I don't know that I can, having not been allowed to intervene and engage in any discovery, et cetera, whether I can meet that very high burden Your Honor is suggesting at this stage. But I think there is evidence in the record to indicate that this was an improper transaction, that it was concealed from my client extensively, even after she became aware of it during the divorce and became aware that there were settlement negotiations. The actual terms weren't disclosed until December 27th.
Was I want to make sure I understand the terms of the settlement agreement.
Yes.
And did they include a payment of $250,000 to Daynard?
Yes.
That was in addition to the transfer of the condominium?
Correct. That's correct. And it was allegedly for all of the attorney's fees incurred during the litigation. So you have, this was originally a $550,000 loan.
Well,
you have,
like it might be in addition to attorney's fees, if I'm reading paragraph 2 of the agreement.
It's a confusing agreement, but I can, yeah, it's a confusing agreement, I think.
And would that money come out of, I guess I'm wondering, are all of the arguments about what was or was not a part of the marital estate and what was or was not transferred improperly out of the marital estate, whether by dissipation or fraud or collusion or deliberate concealment, are those all being made and decided down in Florida?
I think some of them can be. I mean, certainly Mr. Daynard is not a party to and won't be before the Florida court. I suppose he could be.
What difference does that make?
Well, I think that I think there's two different parts to that question. One is, certainly, can my client argue in her Florida divorce, my marital assets have been dissipated and he dissipated them, so I should get a larger percentage of what is left because of that. She can certainly argue that, but as we establish and the record reflects, this condo is a significant portion of the marital estate. So she might get an order saying he dissipated that asset and you get more. There may not be any more to get because
if the issue isn't one of dissipation, but fraud, and that there's either he retained control of the property or there's some alternative consideration that changed hands, why couldn't you ask for that remedy in the Florida court as well?
I guess I'm a little confused by the suggestion that because she could pursue that remedy potentially in Florida, that means she doesn't have a right to intervene in this pending proceeding before it came to its conclusion. I think that, but to the extent that that is the case, once the asset is gone, it's gone. Right? That's why she sought to intervene. This is a major part of my marital estate. I'm in a divorce. I'm trying to divide up my marital estate. But if you allow this to go forward without me being able to step in and halt the proceedings here, there won't be anything. It won't be there for me to divide. And I think that goes back to Justice Wolohojan's point at the beginning: is could Florida have stopped all of this? Could Florida have intervened and issued an order? I don't practice in Florida, and I'm not her divorce attorney there, but I think it's difficult to take the position on the one hand that she has no cognizable current interest in that property, but on the other hand, argue that the Florida court could have protected that interest and restrained the parties and the Middlesex Superior Court from addressing the litigation before it.
I think we have your argument. Let me see if there are any further questions. No. Okay. Thank you very much.
Thank you.
Attorney Banthen.
Good morning. If it pleases the court, I have 3 points that I would like to make. The first one I'd like to focus on is the inquiry around timeliness. Now, any intervention has to be timely, and that's a factual inquiry. And so when the judge considers the question of timeliness, a key component is, could the intervention have been brought earlier? Now here, the answer is yes, because we have a settlement in September and an intervention late February. Now, so the question then becomes, well, what's the justification for the delay? And Jennifer Howard's justification for this delay is she had no idea about the settlement. She had no idea that the unit was being sold to settle the litigation. No idea her son was being made to move out. Two problems with that. The first one is that why didn't she intervene earlier? If she had concerns, she knew about this litigation, she could have
Well,
intervened.
I have to say here that this is all very confusing to me because there are no findings by the judge. So I don't know we can't make these findings in the first instance here. So as to who knew what, and then that seems to me the critical problem with your timeliness argument is that, maybe not, but there are no findings.
Well, my understanding is that the court could inquire of Justice Ricciuti of the rationale for his decision.
All right, so is that what the relief would be in your view if you wanted us to rely on the timeliness?
Yes, so to ask him what was
the relief would be to ask
Yeah.
for further findings?
Yeah, and there,
But counsel, even on your view of the timing issues though, you would have shown that she could have intervened sooner. But isn't it also true that you can view this as the circumstances showed escalating concerns, so that it may not have tipped the balance, when the suit was initially filed, but then when the settlement became public and the son is being evicted, that's when, weeks later, she moved to intervene. So the question isn't necessarily could she have intervened earlier, but was this too late?
Well, the son was planning to move out, but I get what you're saying, the concern about the allegation of eviction. What is missing, what's glossed over in Jennifer Howard's briefing on this is that Tim Howard breached the settlement agreement. So the settlement agreement was for the sale of the unit. Everybody was happy. Everybody was planning for it. And then he breached that settlement. The unit was trashed, doors ripped off hinges, jams, holes in walls, graffiti with curse words. It was really trashed. And because he breached it, the settlement agreement had consequences for that breach. And it was only after that breach that the $250,000 for Daynard's permissive counterclaim, for example, and his full possession and ownership of the full possession of the unit. Those were the consequences of the breach. And so what that raises, and this is another inquiry in the timeliness argument or inquiry that has to happen is this prejudicial against Daynard? And what we see is that it is prejudicial. People are happy. Then Tim breaches the agreement. Then all of a sudden, Jennifer says, "Oh, she has no knowledge."
I mean, all intervention potentially may work some prejudice to some, already a person who's already a party to the litigation. So I think we'd have to talk about undue prejudice in some sense.
Well, I think we can talk about that here. I mean, obviously we can talk about it. I think that's a good point, Your Honor. And what we really don't know what Jennifer is seeking. She's never filed a pleading in this case. She never articulated a claim of collusion until the Friday before the Monday summary judgment hearing in a reply brief. And she didn't allege facts. She certainly didn't meet the Twombly-Iqbal standard adopted in Massachusetts under Ignacio v. Ford Motor Company.
Did you raise these arguments below?
Yes, we did. In section C of the opposition to the brief, we say, where's the claim? Where's the evidence? And so we did raise them. Now, we could not say that.
I have to say, I want to make sure I understand correctly that motion for summary judgment was allowed on the basis that the husband did not timely submit summary judgment materials as required. Is that correct?
That is correct, because
the summary judgment record was not decided on the merits of the legal arguments presented in that motion?
Well, he violated a procedural order from the judge instructing him.
So it was on, I understand that, but it wasn't on whatever legal arguments were presented in the summary judgment motion. The summary judgment was entered for failure to comply with the procedural order of the court.
His failure to, his repeated failure, but.
Okay, but,
yeah.
all right. So, and I think we can all agree it's undisputed that everything at issue here, the condominium, and arguably even any funds used to satisfy paragraph 2 of this agreement for judgment, the $250,000 plus the attorney's fees and costs, are potentially assets of the marital estate. The parties were married at the time of this agreement. Is that correct?
They were married in 2017. I believe so.
Right, but they were still married. And why is it that that is not a sufficient interest when there is an ongoing divorce proceeding in the subject matter of this litigation between the husband and Daynard, and in the judgment, in the agreement for judgment, to require the judge or permit the judge to allow the wife to intervene?
Well, it's the failure of the intervention was to provide the basis for it. Why? What is the base? She has, I will assume for sake of the argument that she has some not equitable claim, but she can say that his property should be considered in the full division of the property. But the problem here is the failure to state a claim. She failed to say, you know, the claim that she made was a one statement, oh, there's collusion here. And she failed, she doesn't have to prove facts, certainly, but she has to allege facts sufficient plausibly to suggest that she's entitled to the relief. And the relief that she's seeking, and just to return to the prejudicial question that was brought up, because any intervention might be prejudicial, but in this case, it's extraordinarily prejudicial because it unwinds the litigation settlement and takes this case back over a half a year after years of litigation.
Counsel, your argument would be a lot stronger if the original 2017 agreement and the settlement of that litigation over that agreement were just ordinary, straightforward transactions. There's a lot here that on the surface makes no sense, or to use a technical word, smells. And in that context, how much did the wife have to allege in order to get over the initial hurdle saying, let me in to the dispute here? The agreement doesn't make a lot of sense. The settlement has aspects of it that really give one pause. And there's a lot of unexplained stuff here.
All in the context, I would add, of a divorce proceeding that would make the subject matter at issue in this litigation part of that marital estate in that separate proceeding. So that's the context.
Yes, Your Honor. Understood. I mean, just to clarify, to respond, the 2017 agreement, and Jennifer Howard alleges in her reply brief in this appeal that the 2017 agreement was intentionally concealed from her. And that's one of the facts. Now, the 2017 agreement was, yes, it was complex. doesn't mean it's by standalone that it's problematic. And I know that there was a preliminary injunction, but that was preliminary. And after discovery, there was a settlement. So, but let me go back to that. She said she's intentionally concealed it. Now, this factual allegation is implausible, because she admits that she had no ownership right in this property. She was not living there. She didn't file divorce until 2 years. So to use that 2017 agreement as evidence of collusion, or to say that that's should be considered here, it doesn't make sense. Yes, it was complex. Yes, both parties are very sophisticated attorneys, as Jennifer Howard, they're both sophisticated attorneys. They both put it in writing, very clearly done. But just because it's complex doesn't mean, it's wrong. And as far as the settlement agreement, what can I say? This was years of litigation, and the parties negotiated for weeks, and this is what they came up with. And the consequences for a breach can be written into a settlement agreement, and Howard breached the agreement. So
it's not clear to me that the judge didn't simply deny the motion to intervene, thinking that once he had allowed summary judgment and the case was essentially dismissed, that there was nothing to intervene in.
I'm sorry, you cut out for a second. I'm sorry, would you say that again?
Sorry about that. It looks to me perfectly plausible from the record that the judge just denied the motion to intervene because the case ended when he allowed the motion for summary judgment. It doesn't appear to me, but please correct me if there's something that would indicate to the contrary, that the judge considered whether anything he was doing, either in allowing the motion for summary judgment or denying the motion to intervene, could have an effect on a pending divorce action.
In the record, he just denied the motion. He endorsed the motion. So
we have no way of knowing that the judge considered what the ramifications, what the collateral consequences of his decision might be.
I assume the judge read the briefing. In fact, he asked if it was briefed at the hearing, and I said, yes, Daynard's opposed it. So the briefing is before the court. We have 9A certificates regarding our factual statements. As I've said in the brief, Jennifer Howard's briefing is missing a 9A certificate, so there's no attestation to anything, any facts in her briefing. So I assume the judge relied on the briefing and came to his conclusion. So the timeliness and the fact this is prejudicial. One other point I want to respond to is the fact that Jennifer Howard has said that, look, this is just being given away. I didn't know. This is way too generous. This is too much. And what we're missing here, again, and I touched on this point before, but I just want to echo it, that there was a settlement agreement in place that allowed for the sale of the unit, division of the sale proceeds. And it wasn't until Howard breached that by failing to clean up the unit that Jennifer and Howard's son, and when he trashed the unit by failing to clean it up, it wasn't until that point that she claimed, I have no interest. She denied the emails and texts and said, I have no information about this. This is not fair. And that basis, as I said in the timeliness argument, is not sufficient. Thank you.
Thank you. Let me check to see if there are any further questions. I don't see any. Thank you both for your argument. It's an interesting case, and we
And we are back live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this fashion, all the ordinary rules of oral argument apply, including that each side receives only 15 minutes to argue and there is no rebuttal. With that, I'm going to call the case of Simmons versus Hallstrom, case number 2020 P0576. And attorney subject, we are ready whenever you are.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Attorney Chris Sobchak. I'm here representing the appellants, the Simmons family. We're here before the court because the Simmons, who have suffered a horrible loss and a loss of their baby, several years ago looked around for a personal injury lawyer to help them seek justice. After looking around, they ended up hiring the Hallstrom law firm. The process took about a year plus of the initial discussions with the lawyers for them to retain their firm. And once they were hired, they prosecuted the claim almost to the eve of trial. Then, as the trial was
that period, at some point, you were a member of that firm as well?
Yes, Your Honor. I was there. I was an associate at the firm initially. And actually, part of the reason is when I left the employment in January of the year before the trial, Mr. Hallstrom then decided to drop the case right before the trial was scheduled by demanding that the plaintiffs immediately give him $55,000 for him to take the case to trial. The plaintiffs did not have the money to pay at the moment, and therefore the court allowed Mr. Hallstrom to withdraw. They were unable to find successor counsel because as soon as the court released them released Mr. Hallstrom from the case, Mr. Hallstrom served on them a lien for nearly $150,000 for all the work that he allegedly performed in the case, all the way up to trial. The case was not prosecuted and the case was dismissed. Then approximately—
Counsel, can I just jump in? As I understand the agreement, the retainer agreement, neither side was obligated to pay the expert fees. The agreement kind of kicked that can down the road. So fast forward at a point where the fees accumulated to a certain point, assuming I'm correct in how the agreement is to be interpreted, as I understand it, the Hallstrom firm did not have an obligation to prosecute the case, but it really came down to a question of timing. Namely, it's a common occurrence if you go before a judge and seek to withdraw, the judge says, well, you may have good reason, but we're on the eve of trial, you can't withdraw now. But this judge, the federal judge, let the Hallstrom firm out at that point. Why doesn't that essentially resolve the question before us?
Because the withdrawal was not for any reasons that the Simmons were able to oppose. The withdrawal, the judge basically said, you have a lawyer here that doesn't want to represent you anymore, so I can't force him to represent you. And it's the Simmons did not litigate the matter before the federal court. They were not represented by counsel. In the summary judgment opinion, the trial court in this case is erroneously said that they were. The counsel that was at the hearing were the earlier counsel that they were there just to provide factual information, but none of those issues were argued before the federal court. So
well, there was an in-camera or communication with the federal judge, correct?
Yes, Your Honor. The in-camera communication
and we don't know what was conveyed to the federal judge. That's not in our record, is it?
That's correct.
So how can we possibly second guess the bases for the federal judge's decision?
We can't, but it has no binding effect on this case because the case is here not whether or not the federal court correctly or incorrectly let Mr. Hallstrom out. It's whether or not Mr. Hallstrom breached the contract to the plaintiffs first, and as also whether his firm's actions, both from the time he retained them all the way to the time where he afterwards went after them by having his firm sell the alleged bad debt to them and he sued them, are unfair and deceptive. And there is no case, to my knowledge right now, that has a one court's allowance of a withdrawal prevent all other claims relative to potential the entire relationship.
Right. I'm right now, as far as I understand it in this appeal, and please correct me if I'm wrong, what we're talking about are your client's claims against the firm.
Yes,
that
Your
right?
Honor. Correct. It's when
So-
when my clients were sued,
And
they
so
counterclaimed.
take them, right, let's take them one by one. You've got a contract claim, and the allegation is that the firm breached the contract when it withdrew from representing them in the underlying medical malpractice case. Have I correctly characterized the claim?
Yes, Your Honor.
Okay, that claim, that's the essence of Judge Milkey's question to you, is why is that claim, why isn't that claim taken care of by the fact that the federal judge allowed the withdrawal?
Because as the judge Malky already said, and you yourself already said, the facts of why the court allowed it are not before this court and not in this case, and therefore it cannot have any prejudicial or a binding effect on this case. It was still a breach of contract. Whether one court says, I'm going to allow you withdraw, doesn't affect all the promises that went into that contract. It was just a contract for representation.
Your argument is that despite the withdrawal, that the law firm needed to do something, needed to stay in the case, even though it moved to withdraw and that motion was allowed.
My argument, Your Honor, is that even a court's allowance of a withdrawal does not preclude a claim on a breach of contract on that underlying contract, because the court that was
and
hearing.
what provision in the contract do you say required the firm to continue with the case despite the allowance of a motion to withdraw? Please point me so I can see. Just give me the page number in the record appendix and the paragraph and specific language in the contract. There
isn't a specific provision in the contract. The motion to withdraw is the breach of the contract. So the firms.
Which provision of the contract prevented the firm from filing a motion to withdraw? Again, I'm going to ask you to, it really helps me if you give me a page number.
I understand, Your Honor, but there isn't one. And that's the problem with the contract. The case before the honor here is on summary judgment, and there's issue of factual disputes. There is nothing in the written contract which was sent approximately 8 or 9 months after the firm was actually hired. The initial contract was a verbal promise that we hire you, you will get us justice, and you will do. And then the firm promised to do so until the trial. When they, on the eve of trial, moved to withdraw, that was the breach. My argument, my response to the question from the court earlier was that if a single court allows a motion to withdraw, that has no binding effect on the breach of contract claim, which happened beforehand, because courts may allow motions to withdraw for whatever reasons they have, and they this and all the possible issues ranging into this breach of contract were not argued before the federal court, and they're certainly not in this record because they're not on any, they were in camera, and there's no evidence of what was actually argued.
So your breach of contract claim is not premised on the language of paragraph 4 of the agreement regarding costs. You're alleging some sort of earlier promise?
Correct. And as the trial court found in the first summary judgment motion, is that there is sufficient factual evidence that to go to jury that there was a first contract sometime in January, not the December 2019. Right.
I just want to be clear. You're not alleging breach of paragraph 4.
Correct. The breach is from an earlier contract. The contract was an oral contract that was the Simmons hired Holstrom Law to prosecute the claim. Subsequently, the law firm sent a written contract that was never explained, and I would argue is ambiguous, that includes this paragraph that talks about the costs, whether they are covered by the firm or not, which then the Holstrom used as an excuse to pull out in the last minute.
Counsel, to what extent are you arguing a violation of the covenant of good faith and fair dealing? And if so, was that issue raised in the trial court?
It was not raised in the trial court. The breach, my argument is that any breach of contract has that built in, especially when you have a contract with unequal parties. Here you have customers of law firms and lawyers who have an ethical obligation that are held to a higher standard to not basically take advantage of their clients. But that issue was not argued on the lower level.
With respect to the oral contract, Is there any evidence in the record as to, in the summary judgment record, that one of the terms of that oral contract was that the firm would not ever file a motion to withdraw?
No, the issue of the never filing a motion to withdraw was never addressed by either parties. The
Okay,
only
so
evidence in
how-
the record,
And excuse me then. So if there is no evidence in the record to suggest that that was a provision of the oral contract, how can filing a motion to withdraw constitute a violation of that oral agreement?
because the oral agreement in the terms of the contract was that the firm will represent the Simmons towards trial, towards conclusion. So even you can have a term that's not specifically, but addresses what was being addressed here. So when the term
Okay,
is,
would you please tell me by page number where in the record I'm going to find the evidence of what the terms of the oral contract were?
unfortunately, Your Honor, I don't have it right. It's the testimony of the plaintiff from his deposition, because there was no written contract. The only thing that subsequently the trial court addressed was that was collaborated by Mr. Holstrom's affidavit that he sent a few months later, during which he claimed that Ms. McKenna was an agent of the firm and was asking for money for her work that was done on behalf of the firm.
Okay. Counsel, could we turn briefly to the issue of damages? Don't you, to show damages, don't you have to prove the so-called case within a case? And for that, don't you need an expert?
I would agree, no, but the simplest way to address the damages is the one that's undisputable, emotional damages. Both the breach of contract claims and the 938 claims allows for emotional damages. And here there was evidence before the court that the Simmons suffered emotionally, both by Mr. Holstrom's actions when he withdrew from them and when he then had the firm sell the case to himself so he can prosecute him on his own, allegedly per se, for the cost that he never on a case that he never got them a result.
What's your best case that you're entitled to emotional distress damages for a breach of contract action?
The St. Charles versus Skander, 38 Mass Appeals scored 155 is on the contract case, and the Tyler versus Michael Stores is on the 938 case.
Those are in your brief.
Yes, Your Honor.
Can you tell me as succinctly as you can what the violations of Chapter 93 are in your view?
That's a little bit more complex. Initially, it was just the withdrawal because there was no evidence. As discovery was undergone, then the third amendment letter amended the violation to include this whole ordeal of where the firm was allegedly selling the cases to Mr. Holstrom personally, then selling it back, using its resources just to prosecute all these former clients.
Okay,
But
was that what was the timing of that third Chapter 93A demand letter vis-a-vis the motion for summary judgment?
it was served on the same day. As
It was served on the same day as what?
As the second motion for summary judgment was served.
Was served or filed?
Served on the plaintiffs because it was also concurrent with closing of discovery in phase 2. So when phase 2 discovery closed, the second demand letter was served and the Holstrom firm served their motion for summary judgment. It wasn't filed.
The motion for summary judgment related to which complaint? The first amended complaint?
Yes.
And in that first amended complaint, I didn't see any allegations of the conduct that's in the third Chapter 93A letter. Am I correct?
There were some allegations, but there were not in the initial letter that was served because
I'm talking about the complaint.
Correct. In the complaint, there was some.
The first amended complaint, what paragraph contained an allegation that I thought it was the withdrawal from the case that was the basis for the 93A claim.
I'm pulling it up, Your Honor, right now. This is a paragraph.
And let me see what page, maybe 42, the one that starts on page 42.
It's the one that said insurance, sure, Your Honor. I'm unfortunately, with all the parties moving forward, there's multiple amended complaints.
If the, we'll try to find it afterwards. If the amended complaint that was the subject of the summary judgment motion did not allege anything other than the withdrawal from the underlying med-mal case, how can a subsequent Chapter 93A letter save that claim?
Because the damages were and the 93A violations were still ongoing. But I'm 100% certain that it did. It just didn't have, was not addressed in the letter, because at the time that the court trifurcated the case, count 1 was the count for breach of contract that related to the underlying case. Count 2 was the 93A claim that included the pulling out and the back and forth selling of the cases and the debt collection actions.
I think you're right about that, counsel. And count 2, paragraphs 106 to 110 do seem to raise that claim.
And I
agree with your reading of the complaint, in other words.
I apologize for running out of time, but if there's any other questions, I'll address on the remaining issues. Unfortunately, there's a lot of them in here.
No, let me check to see if there are any other questions. All right, thank you very much. Attorney Wiegand?
Yes, good morning. May it please the court. There was no error by the Superior Court judge in the Suffolk action as to the rulings for summary judgment on the contract and 93A claim. And there was likewise no error by the Superior Court judge in the Middlesex action, which is also consolidated, in dismissing that subsequent action based on principles of claim preclusion. As far as the summary judgment rulings, I'd like to make 2 points this morning. Number one, there was no error in finding that there was no cognizable damage under either theory. And number two, independent of that, although perhaps not directly addressed, but an independent grounds for you to affirm, is that the record, no matter how construed, does not support a viable breach of contract or 93A claim. So turning to the damage portion first, the ruling by the Suffolk Superior Court judge, as you see from the papers, there were 3 components of damages that were sought under both theories: costs, emotional distress, and the purported value of the underlying malpractice claim. All of them, based on the record, were not cognizable damages. As to the cost and looking at the breach of contract, the costs were those that were purportedly expended in defending against when Attorney Hallstrom brought an action seeking to recoup the monies that he advanced in the underlying case, which wasn't ultimately pursued. The breach of contract, which is, I'll get to more in a detail in response to Your Honor's question as to what that contract was, but it doesn't provide for costs. And costs are prevailing party by statute. It's not an item of damage for breach of contract, as found by the Superior Court judge. As to the
Attorney Subcheck says that there was a lien.
A lien.
A lien of some sort. I thought I heard him say that Attorney Hallstrom sought a lien or some kind of attachment of $150,000.
No, I think at one point he put a bill together, that is Attorney Hallstrom, of his time, the time that was expended in working this case. Under the contingent fee agreement, there's a provision in there that if he's discharged, he could seek to recoup his hours spent on the case and his staff at $350,000. That may be what counsel is referring to, but it didn't become an issue in the litigation. So
is it unambiguously clear that there has been no recovery of unpaid bills or litigation costs or anything against the Simmons?
That's true. It was initially brought, and then there was a standing issue that was determined by the court that Hallstrom didn't have standing, only the law office. So Hallstrom was dismissed, and it was just never pursued. All that was left was the Simmons's claims for breach of contract in 93A. So the answer to your question, it was never collected.
Why can't an unlawful transfer by a law firm of a debt or a claim for fees and litigation costs, why can't an unlawful transfer or assignment be the basis for a Chapter 93A claim?
All right, well, I would take first issue. I don't think it was unlawful. I know that the judge in earlier ruling found that Hallstrom didn't have standing, and I think it was because there was not consent by the Simmonses to that assignment if treated as a personal services contract. But I think in fairness, it wasn't the personal services aspect being assigned, it was to seek recoupment of those advanced monies, which I would suggest didn't need the consent. But even if you say it does, it's not a 93A claim. It's a lot about nothing in that a law firm in seeking to collect monies from owed by a client is not violating, for instance, the Fair Debt Collections Act, because it's not in the business of collecting debts for others. And
Yeah,
so
but
whether it was
counsel, on what theory was any debt owed to the law firm? That's what I'm having a problem with. And speaking only for myself, there's a shock to conscience aspect of the efforts to collect any debt from these plaintiffs under these circumstances.
No, I understand that. And just to reiterate, it wasn't pursued. But with your Honor's attention, I think it's to the written contract of December of 2009 contingent fee agreement does have a sentence in there that the Hallstrom Law Office, while it didn't have to, could advance monies and costs and expenses, which were done, and that it could stop at any time, and that it had a right to seek reimbursement from the clients for those monies. Now, whether a law firm decides to do that or not is up to them, but there was language in that written contingent fee agreement that provided that.
When you say it wasn't pursued, it was pursued. It was transferred to Hallstrom individually. He filed a lawsuit, which ended up getting dismissed.
That's true, Your Honor. All that is true. What I'm saying is that based on the ruling, it ended up back to Hallstrom Law Office, right? They had the right to pursue it based on the assignment purportedly not being valid, but the Hallstrom Law Office never pursued it thereafter. It was my point.
Because someone finally showed some good sense not to pursue it.
Your Honor, I have no quarrel with that.
Okay, but they did initially transfer it to Hallstrom individually to pursue. And the Simmons claim that they incurred litigation costs to defend against that unsuccessful effort. And if we were to accept the notion that the steps that led to that initial collection action could constitute a Chapter 93A violation, why is it that the defense costs to that litigation aren't Chapter 93A recoverable damages?
Well, I think as the Superior Court judge found that the costs that were incurred were a result of Attorney Hallstrom bringing the action. The only defendant in the case, Hallstrom was no longer a party, and the only claims that the Simmons were making was against the law office.
Right,
So,
but how did Hallstrom get the claim?
Hallstrom got the claim initially through the assignment, which I don't think was necessary, but they were treated as separate entities for that purpose.
Right,
So
and the assignment was done for what purpose? At least on summary judgment, looking at the facts most favorable to plaintiffs.
You know, Your Honor, in fairness, I think the record is pretty devoid of any explanation as to that. It could have been the thinking that in order for a law firm couldn't act on its own to without representation to make a claim, which I don't think is correct. I don't think there needed to be any assignment. But it was for purposes
of collecting money from the Simmons. The assignment was made for purposes of collecting money from the Simmons.
It could have been made for purposes of the law firm being that a law firm or a corporation can't act without counsel. That could have been the thinking. Not necessarily to, but the ultimate purpose was to seek recovery of those.
It's very hard for me to just say the line of responsibility stops with Hallstrom for these damages. The chain of events started with the law firm making a decision to whether it was assign or hire Hallstrom or whatever, have Hallstrom collect on this debt.
I understand. I don't think it's wrongful. As to go back to Justice Milky's question, there is a provision in the contingent fee agreement that was signed by the Simmons that the law office had the right to seek recoupment of the advanced fees.
How does that square with the other provision that says they aren't responsible for paying expert fees?
Well, I think it starts out, it is perhaps reading the whole thing. I think the idea was, look, you're not responsible for fees in the normal course, except as the following, and that's the language in the contingent fee. And then it's talking about focusing in on the situation where the law firm decides to advance monies, which is what was done in this case, substantial monies and substantial investment in this case at Hallstrom's risk. But he reserved the right to be able to stop that advancement, and that the client agreed that if that's the case, he had the right to seek reimbursement of those monies. So probably awkwardly worded, Your Honor, but I think that was the intent.
Counsel, do you agree that the federal court, notwithstanding the language of the contract, the federal court did not have to let the Hallstrom law firm out of the case on the eve of trial?
No, it absolutely could not, for the very reasons you identified earlier, saying, look, I get it, but it's too late now. But the judge evaluated it. There was a hearing. We don't have the in-camera.
But if the judge could have kept the firm in the case, to what extent are we bound by the decision of the federal court judge on that?
I think you're bound by it on a sort of a collateral estoppel and giving effect to a federal court's decision, at least as so far as any of these claims deal with the withdrawal. And I cited in my brief, I have, Justice Milky, I haven't found a mass case on point, but I did cite in the brief a handful of cases in other jurisdictions which have so held.
From places like Arkansas and Washington State.
So I think a very good one that was articulated well was the Supreme Court of Washington, yes.
Could I ask you about the demand letters, the 93A demand letters? So there was one sent in October 2015, and then a second one was sent in February 2017, and that letter does have an allegation that the law firm should never have sold the alleged claims to Hallstrom. So why is that not enough to give notice? Is it because the letter was not addressed to the law firm? It was addressed to the insurer. Is that why?
I think, yes, Justice, and I think for two reasons. One, your observation was never argued below, number one. But number two, that letter was not directed to the Hallstrom Law Office. It was directed to the underlying insurer in asserting the insurer's claim. So for that reason, I don't think it would be effective. You have to give notice. You have to be, it's not, the 93A letter, while not overly demanding, does have certain basic requirements. You got to direct it to the right party, and you've got to identify the claim. So I don't believe that February 2017 letter is operative as to the Hallstrom Law Office. And again, that was not even relied upon or argued below.
The only operative letter as far as the law firm is the October 2015 letter. That would be your position.
That's right. And as you probably know, they tried to rely on the one that was submitted the day before the summary judgment hearing, and the judge addressed that, found no excusable, found it no reasonable excuse for that delay, and so it wasn't deemed operative. And so to the extent that the 93A claim was based on the collection efforts outlined in that letter, it was barred. So again, I think just turning to the Middlesex Middlesex action, Justice Wilkins there, I think, properly dismissed that subsequent filing, relying upon the Suffolk judgments that had
Well,
been
there
entered.
is no final judgment, right? Because it was appealed.
Final judgment in the Suffolk action, I would say there was. I mean, there was phase one was,
Even if it's appealed?
well, correct. I understand that. But I was thinking of the fact that the claim against the bad faith claim, phase 3, was stayed and severed until resolution of the underlying claims of contract in 93A. But as far as the Middlesex judge is saying, is there was no error in him finding that claim, based on claim preclusion principles, was barred by the summary judgment ruling. Summary judgment rulings are entitled to claim preclusive effect.
I'm still not understanding. Is there a case that says it's a final judgment even if it's been appealed?
Well, even if it's not a final judgment, I think I should say a prior pending action would be the basis for not allowing the Middlesex action to go forward, because any claims were or could have been brought in the Suffolk action. So I think it was reasonable for him to dismiss the case. And he understood, if you look at the hearing, that there was going to be an appeal. And so, again, I don't think that was any errors as a matter of law. Unless there's any further questions, I would leave the remaining arguments to the brief.
Let me check with the panel. Seeing none, we thank you for your arguments. It's an extremely interesting case, and we've been helped by your argument.
And we are back live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this fashion, the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of AO versus YA, case number 2020P0174. And I'm going to remind both parties that are both attorneys, that the case is partially impounded. And with that, Attorney Shenevert, we're ready whenever you are.
Thank you. May it please the court, my name is Dana Shenevert and I represent the appellant plaintiff. In this case, we are respectfully requesting that this court vacate the decree or the judgment that dismissed her complaint for 209A. There are 3 points that I'd like to address with the court today, having to do with mootness, the misapprehensions of fact, both by the appellee in the brief and also by the trial court, and then the errors of law committed by the trial judge at the time of the hearing. Now, I'd like to start with mootness. One of the arguments of the appellee's brief is that this case is moot, a non-issue, because not only did the ex parte order expire as a matter of law, but the complaint was dismissed. And in support of that proposition, my brother cites to Prezado. However, there is an exception to this doctrine of justiciability, which is where there's conduct that is capable of repetition, yet evading review, and that is the case here. Now, the burden of proof there is, this exception is applied in extraordinary circumstances where the plaintiff can reasonably show that she will be again subjected to the alleged illegality, right? And that is the case here, simply because these parties share a child. Their interaction is required by their court-ordered parenting time custody arrangement, and the parties concede that this is a highly conflictual relationship, that the parties have been embroiled in a hotly contested custody battle for the 5 years prior to the filing of this complaint, and according to the docket for the foreseeable future. So it is our
Weird thing about mootness in this situation is normally we see this mootness argument raised where someone says the appeal is moot because the underlying order has already expired, right? It's just, it was issued, but it took so long that for the appeal to get here for one reason or the other, that it's already run its course. Here, I think that it's a little bit of a different circumstance because the argument is that you're appealing the denial of a 209A, right? You're appealing the denial of an extension.
Sure, yes.
And so that's a little bit of a different circumstance. And I guess the question I have is, I don't know if it's so much a question of mootness, but what prevents your client from going to seek another 209A? As you mentioned, the situation is ongoing. And so she always has that recourse available to her, does she not?
She does, but the issue here is just what Your Honor mentioned, is that you file the complaint. If the plaintiff file the complaint ex parte, let's say, plaintiff meets the burden, the ex parte issue is ordered, or the ex parte order is issued, then not more than 10 days later, there's renewal hearing, at which point either the ex parte order is extended or it expires. So this is the cycle that can go on and on and on before, and you can continue to appeal those orders. But then by the time you get onto the appeals court docket, each and every time the order is going to have been expired. So that is why this continues to be a justiciable issue, is because it can continue to happen and evade appellate review.
Counsel, what is the state of the larger family and probate court proceedings? Are they all resolved now?
They are not, Your Honor. And I don't want to necessarily go off the record too much, but it's still highly contentious. It is still ongoing. There is no final judgment having been entered in that case.
No, wait, the reason I bring it up is, besides that issue, a lot has happened, I suspect, between the time this order was denied and today, which goes to Judge Wallahojan's point that there is nothing that is per se precluding your client from seeking a 209A order if circumstances warrant it.
Sure, and I will say, without going too far off the record, and I will qualify what I'm getting ready to say by, I am not my client's probate and family law attorney in that family law matter. But what I know, based on the underlying litigation, it is still highly contentious, and these issues still exist. And so what the focus...
The weird thing is, let's say we were to agree with you that the judge should not have denied this order. Would that mean that it would go back for rehearing on the record at the time, which is sort of what would normally happen? Or is it that, which doesn't make a lot of sense to me, because as you know, the situation is dynamic, events have changed. And so why isn't it that the better course is to allow a new proceeding to be filed?
I will say that the course here is, the argument is that the course here is to, well, once you remand, if there is a remand for further proceedings, the current status of the parties becomes relevant. So not only are we looking at the record as included on appeal, but we are also looking at the present circumstances of the parties. And the remand here, or the argument here, Your Honor, is that even if we remand to the same court, these proceedings as they went forward were unfair to my client because the judge erroneously looked at this case through the wrong lens, which is the next issue that I wanted to talk that I wanted to address with the court.
But counsel, if the judge simply didn't believe your client, which appears to be the case, why does it matter what lens he or she looked through?
Well, according to precedent, there are other parts of the analysis. The court's analysis was incomplete. Not only does there need to be a credibility assessment, but there also needs to be a meaningful review of the sufficiency of the evidence. And if you look at the transcript that was included in the record appendix, the trial court questioned my client. The trial court actually heard a motion in the morning, different issue. Then my client comes back to court that afternoon, having misapprehended which court, either the district court or the probate court, had jurisdiction over the matter. And understandably so, because 209A3 indicates that these courts, the district court and the probate and family court, have concurrent jurisdiction over this type of issue. So she was advised, and I would argue she got bad advice from the advocate that said, you need to go back to the probate and family court and have this order extended. So she goes back and she's before the judge who heard a motion earlier that morning. And I wanted to correct for this court that this was not an ex parte hearing. This is the renewal hearing that all parties had knowledge of, or actual notice of, with the defendant having been served with the ex parte order on the night of the incident.
Could I just ask you, so at the 9 a.m. hearing on this other motion,
yeah,
the judge heard testimony. Is that correct?
Apparently, because we don't have those transcripts.
We don't have the transcript, but I gather that the judge heard testimony a few hours earlier.
Yes.
So why couldn't he rely on the testimony he had heard? I'm not understanding why that was improper.
Sure. So what's particularly interesting about what the judge drew out of that hearing that morning was the finding that the Department of Children and Families had unsubstantiated allegations of abuse by the father. This was the understanding that the court articulated. Then in that same line of questioning, my client clarified for the judge that no, those unsupported allegations had to do with her, right? There were unsupported allegations that she had abused the child, right? But she corrected the court to say, no, it wasn't the unsubstantiated allegations against the father. It was unsubstantiated allegations against me. So what the court did, though, was he misunderstood that. He took that hearsay, that impermissible hearsay. There's no indicia of reliability. Now, there are, when we talk about testimony, because this is testimony that apparently maybe either party, it's unclear, gave about the DCF involvement. This requires some...
Without the transcript, how do we even assess this claim? We don't know what the judge heard at that earlier hearing.
And that is my point here, Justice Shin, is we don't know what the judge heard, but what we know is what
put the transcript into the record in order for us to review it.
I didn't have it, Your Honor, quite frankly. I just did not have it and could not get it in time to include it even in a supplemental record appendix to have before the court at the time of argument. So
that is, in my view, a problem. But I'm also wondering, because I'm looking at page 6 of the hearing transcript, and I'm looking at that, and I'm not sure that I read it in the same way, but maybe I'm misreading it, that the DCF inquiry related to, she says, your client says other incidents.
Right.
But why is, I sort of read that as being other incidents concerning the father.
She says, it says that okay, so this is as the judge is reviewing her affidavit. It says the same thing about the light, the blowtorch. I recall hearing earlier this morning that DCF was involved in the unsubstantiated allegations of physical abuse by the father of the son.
Yes.
Then there could be a reasonable inference that my client's response is an objection based on relevance. That no, that did not have to do with, that's different from what I'm alleging now.
Right, that's what she says. She says that was on other instance, Your Honor, not this most current one.
That's right, yes.
Right. Now we have no way of assessing one way or the other, right? We have no way of assessing which is correct because we don't have the transcript.
Well, but my client testifies it was about his father saying that I hit him and hit the child at the exchange.
Okay,
So
well,
then he doesn't even,
and that's a contradiction with the judge's recollection.
that's right.
Why are we to weigh that? How are we supposed to know that she's correct as opposed to the judge being correct?
Well, I think that that's the issue. There is no indicia of reliability on either one of these statements. However, the judge and the judge takes this statement as part of the evidence and infuses it into his credibility determination, which arguably was not based on the right legal standard. He did not articulate which legal standard he believed my client needed to meet in order to meet her burden to have the 2098 order extended. And then he also just
your client is saying he made a wholesale credibility determination that he did not credit your client. And if that's the case, because we accept those, we just accept those.
Sure, you have to.
But if that's the case, what difference? I mean, Judge Milkey asked this question in the beginning. What difference does anything else make? If he doesn't believe what your client is telling him as a factual matter, what difference does the legal standard make?
Well, the court in this court in IML said, actually the Supreme Judicial Court in IML said that without deference to the reviewing court needs to look at the legal criteria that was used and look at how that legal criteria was applied in a particular case. And that is what we're missing here. It's a two-part analysis, I would posit, justices, that not only does there need to be a credibility assessment, and it's not an assessment of this is going to sound, it's not an assessment necessarily of a particular fact. It's a credibility assessment of the reasonableness, the objective reasonableness of the client's subjective fear. And it is based on facts that are viewed in the light most favorable to my client, because the judge in this case sat and acted as the arbiter of fact. And so what he needed to do was make all reasonable and possible inferences in favor of my client, using the totality of the circumstances and also the proper legal standard. So no, while this court cannot stand and substitute its judgment for the lower court's credibility assessment, it can evaluate the legal criteria which the trial judge used in the application of it, which is impossible to do here because there were no findings that will explain where mother's case was deficient, why he didn't believe. It was just a conclusory, I don't believe you. And under precedent, the inquiry cannot end there.
And your time is up and I see a question, so we'll take the question.
Yeah, just a very specific factual question. The original ex parte hearing was in district court, correct?
That's correct.
And then the first hearing, after notice, was in the probate and family court?
That's right. After
how did that change? How was the case transferred?
It was not officially transferred. What happened was that when my client initially got the order under 204.5 or 209A5 over the phone the night of the incident. She testified that she was advised by Medfield Police to return to Dedham District Court the following day to extend the order. So on the following day, both of the parties had scheduled the motion hearings in the morning. After the motion hearing concluded, my client went back to Dedham District Court and was told by a domestic violence advocate that the Dedham District Court did not have jurisdiction. that was bad information, but my client took it because she's pro se, she's representing herself. She went back to the probate and family court and appeared before Justice Phelan around 3:50, right before the order expired. So another misapprehension of this court, of the lower court, was that this was not an ex parte hearing. This was a renewal hearing with notice that the defendant did not appear at. And
Well, did the defendant have notice that he was to appear in probate court for this?
he absolutely did. He had noticed that the hearing was going to happen. He was served in hand
He
with
didn't
the ex parte.
he didn't have notice that it was going to be heard in probate court.
Well, he was served. The record at
No, but the service would have been that it was going to be heard in district court.
In debt.
And so I cannot explain why the domestic violence advocate advised my client to return to the probate and
So
family
it's
court.
not incorrect to say he was not present or it was ex parte, because there's nothing to show that he knew that this was going to be heard in probate court at that time.
I would say that he had constructive knowledge of a hearing that was happening, and the onus
Where?
would be.
Anyway, it is what it is. We're going to have to leave it there. Thank you. Your
Okay.
time's up.
Thank you.
Attorney Rogers.
Thank you, Your Honor. May it please the court, Matthew Rogers for the defendant appellee. Our essential position is that the judge followed the law. He assessed the totality of the circumstances, correctly applied the law. As Justice Wolahojian said, he made a wholesale credibility determination. It's really the end of the matter in the 209A case. I would like to add that over the past year, the appellant has filed several additional 209A cases against the appellee, and they've all been denied. The ongoing probate case, I don't want to get too far off the record, as my sister said, that's coming up for several motion hearings in September. The appellee has been granted full parental rights, terminating the parental rights of the appellant. There's frankly no way that this 209A order can be issued at this time.
But that doesn't moot this appeal, right?
Doesn't technically moot it, but there's no way that a 209A order could be compatible with the probate court orders at this point.
Well, maybe the orders, I'm speaking purely hypothetically, but the orders would have to be modified. The custody orders, right? I mean, if a 209A order issues, obviously the custody orders would not be able to stay in place. So, I mean, it's not moot. I mean, you argue it's moot, but not seeing how it's moot.
Right. Well, regardless of the mootness, the issue at hand, the main issue, is the totality of the circumstances and the credibility determination.
Okay, counsel, would you agree with the proposition that in making the credibility determination here, the judge was relying in great part on his, I can't remember if it's his or her, but knowledge of the wife from prior proceedings in this larger probate matter?
Yes, Judge Phelan brings it up in his in the transcript.
Okay, what is the bounding principle on that? Say they hadn't been before him in a year. Could the judge just say, well, I remember you and I don't believe you?
Well, I think the judge gave her several opportunities to add anything she would like. In fact, he asked her 3 times, is there anything new you'd like to add? But if you look at IMLA, the totality of the circumstances specifically includes ongoing child custody or other litigation. Frankly, there's no other judge who would be better suited to make that credibility determination than the judge who is actively engaged in the ongoing child support litigation. I think the facts of this case are really...
How does the judge have authority to act on a 209A filed and pending in Dedham District Court without some kind of transfer order or reassignment?
I don't believe that it was ever filed in Dedham District Court. It doesn't, I mean, she filed an application there, but they didn't accept it. They told her to go to the Norfolk Probate Court, and she went to Norfolk Probate Court. She actually refiled a brand new affidavit at Norfolk Probate Court.
Was there a new complaint?
There's a new affidavit. I don't know if there was a new
Was
complaint.
there a complaint filed in the probate court? What complaint was this judge acting on?
There's a complaint. Let's see. The complaint was to Judge Phelan. It was at Record Appendix 30.
Let me look. Hold on. I'm just a little bit slow and behind you. Let me look.
So she did file a new complaint at that time.
Okay. So this would be an initial ex parte proceeding in your view then on a new complaint?
I think that the lines are blurred, obviously. She received a temporary emergency order over the phone the night before, but then she did refile this new application the following day. I don't think that the standard really changes very much, though. It's still the totality of the circumstances and a credibility determination at the end of the day.
How do we know that this on page 30 was filed in probate court?
Is Judge Phelan's name at the top right-hand corner?
It's fair to say it's an informal process on these 209As.
Yes.
Is the docket sheet for that docket number included in the record appendix?
I don't believe it is, Your Honor. It's not.
Well, the check mark on the next to the box for probate and family court, is that something that's filled out by the plaintiff at the very top?
I believe it's filled out by the plaintiff with the help of the advocate.
I noticed that the previous one on page, there's an earlier one that had the district court box checked.
Yeah.
So the earlier one on record appendix 20 filed with the Medfield Police Department.
Do you have anything further? I think we understand your argument.
I just want to touch base on the facts briefly. You look at the statement of facts in the appellee brief. What happens is that, when defendant appellee wins a motion in probate court, the appellant has a history of immediately going to another court and trying to get a 209A order, either on her behalf or on her son's behalf. That happened on October 30th. She immediately went and got a 209A order from Dedham District Court. It happened again on December 4th. So the totality of the circumstances are such that the credibility determination of Judge Phelan is completely supported by all of this ongoing child custody litigation, the timing of the 209A requests and hearings. Frankly, there's nobody in a better position than Judge Phelan to make that determination. And as you know, reviewing courts are to give utmost deference to that credibility determination. And we would just ask that you continue to do that. Thank you.
Let me see if there are any further questions. No, I think we have your argument. Thank you both. For your
And we are back live and on the record.
Good afternoon. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this way, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Vicuna versus Draper Properties, Case number 2020P0831. Attorney Kelly, we are ready whenever you are.
Thank you, Your Honor. Good afternoon, and may it please the court. I'm Tom Kelly, and I represent Lucas Vicuña, who, as you know, suffered a very serious traumatic brain injury when he fell approximately 30 feet off of a roof while clearing snow on February 18th, 2015, at the large commercial facility owned, managed, and maintained by the defendant in this case, Draper Properties in Canton, Massachusetts. The trial judge clearly abused her discretion by excluding the OSHA materials from evidence in this case. Her rulings and statements on the record that OSHA only applies between employers and their direct employees, and that the multi-employer citation policy only applies on construction cases, are clear errors of judgment. It's reasonable to conclude that the inclusion of that evidence may have made a material difference to the outcome of the case. The judge's
Counsel, if I can just interrupt.
Of course.
The threshold question of whether the OSHA multi-employer policy applies is a question that falls to OSHA, correct?
I agree with that, Justice Milkey, and I think that.
But based on this record, if anything, the record would appear to suggest that OSHA didn't think it applied, given their actions.
You're referring to the fact that OSHA did not cite Draper Properties in this case?
Correct.
Well, Your Honor,
and did cite the employer.
Yes, Your Honor, and I'd like to refer you to the case of Herson versus New Boston Garden Corp., which is 40 Mass App Court 779. It's a 1996 case, which is directly on point on this case, and that says that the lack of OSHA citations is inadmissible at court. Basically, it boils down to it's the OSHA investigator's opinion. It's inexcusable or inadmissible opinion hearsay testimony. And
we're not talking about whether that citation was admissible. We're talking about whether the lack of citation could inform the judge's decision regarding admissibility of other evidence.
I think I understand what you're talking about, Your Honor, but I don't think that's what the judge based her decision on in this case. I think it's clear from the record. Unfortunately, she didn't give us a written ruling on this matter directly, but her statements on the record pretty clearly indicated that she believed that it was inadmissible because one, it wasn't the multi-employer citation policy only applies to construction cases, and two, because OSHA only applies as between employees and or employers and their direct employees. And I think both of those are clearly, inaccurate and unfortunate errors that the judge made and precluded us from introducing that evidence.
You're saying, had you been allowed to put these OSHA materials in, the defendant would not be able to put in evidence that the agency cited only, I forget the employer's name. The plaintiff.
MV Construction. Yes, Justice Sheen, I believe I think that's a statement of black letter law from the Herson case. I mean, I think if we're allowed to introduce evidence of Draper Properties duties to their own employees under OSHA vis-a-vis fall protection and hazard analysis and things like that for the roof, which was a regular place of employment for their own employees. And I don't think there's any question in this case that Draper Properties does owe duties under OSHA to its own employees. Then of course the defendant can cross-examine our expert or our fact witnesses about OSHA regulations and how MV Construction did or did not comply with those. I think that would be totally fair game. The fact of the matter is, I think at the end of the day, it should be up for a jury to weigh those different things and say, well, is it more the fact that MV Construction and Lucas Vicuña may or may not have complied with fall protection regulations on the very day of the accident? Or does it go further back than that and say, well, Draper Properties under 29 USC 654 section A2, the specific duty clause, had duties going back for 30 years while it had these employees, its own employees, going on the roof of this facility.
I'm not clear on what you're saying was the specific duty that Draper Properties owed to its own employees. I mean, I gathered from the expert disclosure that the substance of his testimony would have been that Draper had an obligation to put together some sort of plan. Is there anything other than that?
Well, Your Honor, I think as relates to Draper's own employees, there are a variety of OSHA regulations that that are those duties for. And specifically the idea of the hazard analysis, or what you referred to as the plan, or what Mr. Payne referred to as a pre-plan or a site-specific safety plan for fall protection, that comes from 1910-132, I think it's section D, which requires employers to analyze a workplace to determine what hazards are going to be present and what personal protective equipment, or PPE, is going to be required to mitigate or eliminate those hazards. And in this case, that could be anything from guardrails to personal fall arrest systems, administrative controls, or other types of training. And there's no question in this case, based on Mr. Loving's testimony, the plant manager, that they never did any of that. He testified he never thought about how anyone could perform
so
work.
Even though none of Draper's employees were engaged in their work didn't involve removing snow from the roof, you're saying that there was some specific duty owed to its own employees in this respect?
Well, I think your honor is incorrect that Draper did have employees removing snow on the roof. Mr. Curnane and Mr. Snell.
This one kind of extraordinary winter where there was a lot of snow, but there's no evidence that they regularly went up there to shovel snow.
There's no, well, the testimony from Mr. Loving is that this is the first time they ever even thought about removing snow from the roof. And I would suggest that that's some evidence of negligence in and of itself, that you have to, you have a large commercial facility that in New England, you have to consider how you're going to get snow loads off the roof for the sake of the people who work in the building. I mean, he didn't become concerned about it until he was worried about the structural integrity of the roof. And I just think that's too late.
But if their plan was to hire professionals to remove the snow anytime it needed to be removed, then what's the duty owed to its own employees?
I don't think I don't think there's any evidence that was their plan, Your Honor. I think that was something that happened, for lack of a better term, in the heat of the moment, when he sent up Mr. Curnane and Mr. Snell to deal with some imminent issues, and also was on the phone looking for basically anybody with a shovel that he could throw up on the roof to get some of the snow off. There was no plan to get the snow off the roof until that moment. And he said, oh boy, I got to do something here.
So is there any other specific duty you're saying was breached other than the failure to implement some sort of plan?
Well, I think that the term specific duty clause, Your Honor, in reference to 654A2 is sort of juxtaposed to what they call the general duty clause in 654A1, which does specifically.
The general duty is owed only to your own employees.
That's correct. The general duty is
for these materials to be relevant to, in this case, there would have to be a specific duty.
That's correct, Your Honor. And I do think that primarily it's this idea of planning, putting together a plan for work that's done on the roof, but also as soon as he sends those two guys up on the roof the week before, they have to comply with 1910.28 and 1910.29, which are the fall protection general industry regulations, those are in the materials that we sought to introduce, and Judge Miller precluded that evidence in addition to the multi-employer citation policy itself, and in addition to that snow removal bulletin that we referenced and the job hazard analysis safety manual. So I think that, when you talk about specific duty and general duty, those are sort of terms of art. The specific duty means that you have a specific duty to comply with the OSHA regulations that may or may not be applicable, or that may be applicable in a given workplace. I mean, obviously you don't have to worry about fall protection if you're on the factory floor and there's no fall hazard. But as soon as you send people up there, and there is plenty of evidence that they sent people up on that roof very regularly. Mr. Loving himself testified that he went up there at least 150 times, and Mr. Curnane testified that he went up there at least 30 times in 4 years. So I think that as soon as you start doing that, you do have a specific duty to comply with these OSHA regulations. And under for instance, in the Teal case out of the Sixth Circuit, we see that duty then extends to employees of other employers who are on your job site performing work. And I think that that's only fair. We're not asking.
Let me make sure I understand, though, the nature of your claim. Your claim was one for negligence.
That's right, Your Honor.
Right? So you're not sort of asserting a direct claim for violation of the OSHA. You're trying to use OSHA regulations to establish a duty of care for negligence purposes, duty for negligence purposes. Am I correct?
That's absolutely right, Your Honor.
So
And evidence
you're
of,
trying to use the regulations to inform the common law standard of negligence for a property owner. Am I correct?
that's a little tricky, Your Honor. It's not for a property owner. We are absolutely not asking the court to say that all property owners in the Commonwealth owe a duty under OSHA to make sure that third-party employees are protected.
So then let's say it's a claim of negligence, common law negligence, against a property owner who hires a subcontractor.
It's a property owner, and more importantly in this case, Your Honor, it's an employer under OSHA. They're a property management company with
It's
employees.
not an employer. That we have to take the claim with all due respect. We need to take the claim you've asserted in the complaint. The claim you've asserted in the complaint is a negligence claim, claiming that this defendant owes a duty to your client. Now, we can all agree, can we not, that the defendant did not employ, your client was not an employee of the defendant?
That's correct, Your Honor.
Okay, so the duty has to be something other than an employer-employee relationship between the defendant and your client. I thought that that meant that the relationship was one of property owner who hires a contractor who employs your client. Did I mistake the nature of the players there?
I think it's too narrow of a view. And what we're saying is that when they are a property owner, and obviously as a property owner, you have duties to people who come on your property. And that was part of our claim. And
right. So but you have to, if you don't mind bearing with me, because your claim is for negligence.
Yes,
and
Your Honor.
The first prong is you owe a duty to the plaintiff. And are you claiming that the duty was the OSHA regulation?
In this circumstance, yes, Your Honor, because
it's not
Draper,
mm-hmm.
Sure, because Draper Properties is an employer with their own employees, and they also have other employees of other employers working in the same area. The duties they owe to their own employees to comply with these OSHA regulations then extend to, under Section 654A2, they extend to the employees of other employers, as we see in these in the Solis case versus Summit Contractors and the Acosta case versus Hensel Phelps, in these Federal Circuit cases that say, yeah, you do have duties under OSHA to other individuals other than your own direct employees.
Are you saying that breach of the OSHA violations constitute per se breach of a common law duty of negligence?
No, Your Honor. As is always the case with a statute or a regulation, it's only some evidence of negligence. We could get this stuff in and a jury could still say, well, you know, your guy was there and he could see whatever he could see and he still fell off the roof. That's his fault. We're not asking for per se at all. We're just asking for some evidence of negligence. That's all.
All right. So then that takes me to, since it's not a per se, it's not per se evidence of negligence, but just could be considered in the mix of the totality of the evidence. I guess that gets me to the question of prejudicial error, even if we were to accept that there was an abuse of discretion in excluding it. How would you then establish the quantum of prejudice that's necessary? Where
I think this was clearly a prejudicial error, Your Honor. I mean, Mr. Payne, our expert, was allowed to testify, and Mr. Green in just a minute here is probably going to tell you all the reasons why he shouldn't have been. And if he had those OSHA regulations to point to as some duty, something that these Draper people were supposed to be doing that they failed to do, I don't see how there's any way that a jury could look at that.
But I mean, MB Construction is an employer that owes a duty to its own employees, presumably including the use of protective equipment, right? Would you agree with that? And the jury found the plaintiff contributory negligent 70%.
That's right, Your Honor.
So
and I think if we had this, I think if we had this evidence, it could have been flipped. And the standard is, oh, did we lose Justice Milky?
No,
I don't
I'm
think
still here.
And I just think, but before my time runs out, Your Honor, I just think that the standard is if it may have made a difference in the outcome of the case. We don't have to prove that it certainly would have. And I think the way juries' minds work, it definitely maybe could have made a difference. And I don't see how there's any way you could look at this important
Standard
evidence
more
and say
onerous.
that it wouldn't have made a difference.
I think the standard is more onerous than may have made a difference. I forget what the precise articulation is, but there has to be some sort of, it has to have had, we have to be able to say it would have had some substantial contributing factor to the verdict. And given that MB Construction itself declined to use protective equipment, I'm not sure where the prejudice is.
Well, I just think also on that note, Your Honor, I know my time is out, but MV Construction, the evidence is in this case is that they basically could not possibly have used protective equipment because of the layout of the roof, because their typical way of using protective equipment was to nail an anchor into a roof, and you can't do that on a rubber roof without damaging it. And there was just so much snow on the roof that they couldn't possibly have used
So then
an acceptable form of fall protection.
How is Draper Properties supposed to provide those two guys the week earlier with fall equipment? I mean, it's
by planning ahead, Your Honor. They could have planned ahead well before they sent anybody up on the roof, and that snow removal bulletin that we wanted to introduce as evidence states pretty clearly, you need to plan this stuff well before snow starts to fall. And nobody is in a position to do that other than Draper Properties in this case. And if Draper Properties had hired MV Construction back in November.
We're gonna have to leave it. I'm sorry, I think we're gonna have to leave it there. Let me see if there are any other questions. No, thank you. All right, Attorney Green.
Good afternoon, and may it please the court. Hearing the tenor of the questions, I think the panel understands the issues. So the first thing I'd like to address is actually a misnomer in Attorney Kelly's argument. He said that the trial judge simply made a determination that the OSHA materials that they sought to bring in applied only to a direct employment relationship and only in the construction industry. That's not correct. And what I would address you to is volume 6 of the record appendix, specifically page 483. Although sort of in the heat of preparing a trial and getting a jury impaneled, the judge didn't have an opportunity to make a written decision regarding her findings as to why she was excluding the evidence. She nevertheless, on the record, articulated why these things were being excluded, and it's not quite as narrow as Attorney Kelly would have you believe. I quote, and I won't go through the entire 2 pages, but on page 483, the court says, I don't think they're admissible. I don't, for reasons Mr. Green just stated, and for what you know, they are not standards of regulation. Don't create, you know, they have the snow removable. They don't create legal obligations. So my point here is that, again, this is recording speech, but if you look at the reasons I articulated at the motion hearing, what we were getting into is not that these were only applied in the construction context. It's that the specific materials that they sought to introduce were not in any way regulations. It was a snow removal bulletin, basically an advisory. It's the multi-employer citation policy itself, which is a directive, is to field investigators for OSHA to determine how they apply these rules. Now, the importance of that is OSHA itself says that the directives that on their face and in the aggregate do not create legal obligations for anybody subject to OSHA. Moreover, and I disagree with Attorney Kelly that it wouldn't have been admissible if they had started talking about OSHA. What they wanted their expert to do was to try to create a duty by saying OSHA has regulations and a multi-employer citation policy which dictates how they interpret those regulations. I am an expert in interpreting those regulations as OSHA would, and I determined that this is a multi-employer work site, and therefore OSHA would have determined it would have been one as well. We now have evidence that would have opened the door for us to introduce the evidence of the fact that the OSHA investigation in question investigated not just MB Construction, but also Draper explicitly. They opened separate files on the matter. As well, they cited MB Construction and declined to cite Draper Properties while offering the opportunity to apply their own multi-employer citation policy. So the introduction of these OSHA materials was correctly excluded. I think the trial court followed the law, although we don't have explicit decisions from appellate courts in Massachusetts. By looking at the guidance from other courts and applying OSHA's own interpretation of its regulations and directives, two separate categories, the judge reached the right conclusion. So not only did the court reach the right conclusion on this issue, but there is no way that the plaintiff appellants can show a clear error of law, no such legal decisions exist, or a material difference in the outcome, where, as Justice Shin pointed out, the jury came back and awarded 70% negligence upon the plaintiff and heard explicit testimony about how NV Construction arrived to this job site with fall protection equipment in their van. Yes.
Sorry. Can I ask you to turn to your cross claim?
I was just about to.
Your cross appeal.
Of course.
If we were to agree with you on the evidentiary question raised in the appeal, why do we reach the issues you're raising in your cross claim? I mean, cross appeal, sorry.
Of course. Ordinarily, where we won the case, it was a defense verdict, you would not. However, there are unique circumstances here. And I would direct you again to volume 6, page 17. This is where, for the first time, the plaintiffs introduced this concept that regardless of the outcome of the trial in this matter, they represented as well the children of the plaintiff. They had not been parties to this case. And they explicitly stated that if they have a finding of negligence, it is their intention to assert claims on their behalf within 3 years of their 18th birthday. So I agree with you.
Why do you decide that here? I mean, it seems to me, don't you just wait to see what happens? And if they bring that suit, then you have that discussion or that fight over whether the outcome of this, the underlying litigation, is admissible in any way. It seems to me tricky for the plaintiff, because if they want to get in the finding of negligence, it seems to me a hard thing to keep out the finding of on the contributory negligence.
And to be clear, I'm not asking for a ruling from the court that precludes them from going forward with any derivative consortium claims that have not yet been brought. I do think that's an issue for them.
No, but counsel, you do seem to be pressing us to reach an issue we may not need to reach, which to me does not sound like a cross appeal.
Well,
or at least a proper cross appeal.
It's not an issue that you do not need to reach. The issue I've brought is, was there a clear error of law in including so-called theory 1 on the jury slip? And the reason I want you to reach that question is because now there's a real possibility that it has some effect. This question directly affects that issue. If the appeals court declines to address that issue, then my client has lost the opportunity to say that that's not even properly before the second court, which may be hearing the consortium claim. So I do think that
claims would be entirely derivative of the negligence claim. And your client prevailed. So I mean, it's just really hard for me to see what you're asking us to do here.
Sure. Well, the derivative claims, the consortium claims, wouldn't be reduced ordinarily by the comparative negligence of the plaintiff. So that's the point. If in fact we did prevail on, I think, the one true theory on this case, which is the retained control theory. Based on that, the derivative consortium claims would be barred. There would be no negligence. On the so-called second theory, that a reasonable property owner had some duty which has not been articulated, the jury came back yes. And since the derivative consortium claims are not reduced by the comparative negligence of the plaintiff, what they are seeking to do is take that incorrect finding of negligence and use that as the basis to go forward with the consortium claims.
You represent in your brief that you objected, I don't know if it was you personally, but that there was an objection below to this, the way that this question was worded. Where can I find that record, the objection?
The objection to the
Question.
theory one on the verdict slip.
The special verdict form.
It's in volume 6 during the pretrial conference. I do not have the exact citation to you, but if you give me the opportunity, I'd be happy to provide that after the fact.
Was there an objection when the verdict was returned?
I would have to check the record on that, but the court acknowledged that it was preserved based on my objection to the verdict slip before it was presented to the jury.
On the next two arguments, your evidentiary challenges to Payne's testimony and this testimony about prior shuffling, what would the remedy there? If we agree with you, wouldn't it be through trial, which I assume that's not what you want?
I agree that the remainder of my arguments are all based on the plaintiff being successful on appeal.
Okay.
That is a clear divide between my arguments, no question. The
So
first,
two
I think, is directly
evidentiary arguments are dependent on
correct.
if prevailing. Although, you know, even then, I'm not sure those issues would come up in the same way there was a retrial. But questions number 1 and 4 are independent.
I'm sorry, 1 and 4.
For the cost, yes. Okay.
Yes, that's correct. So I do think that we can save some time. And in fact, unless there are direct questions on the 2 evidentiary questions, I'm going to rest on my brief on those because they are contingent upon the plaintiff prevailing on appeal. And frankly, as to the 4th question, the cost question, I'm unless there are direct questions, I'm also willing to rest on my brief. I think
what's the basis for that request?
I'm sorry?
What's the basis, statute or rule for that request?
And I apologize, are you referring to the request for the motion for costs and the hearing? It's for the recovery of statutory costs after prevailing at trial. I forget the exact statute, but it has a statutory basis. The costs that can be sought are limited by statute and are frankly relatively small. It's not a recovery of attorney's fees. It's simply costs associated with the trial.
And your point is that the judge just passed over your request.
Yes, it's a very simple issue that we made a request, we asked for a hearing, and it was denied. I think really without basis in allowing us a hearing, but it's a relatively minor issue in the global scheme of.
And the judge has discretion not to allow them, correct?
Correct. The judge could reach the decision that it's not.
So that's reviewed for abuse of discretion?
I believe allowing it without a hearing and based on the fact that we prevailed at trial, it was an abuse of discretion, yes.
But our standard of review is abuse of discretion.
Yes, it is.
On the challenge to the verdict form, did I hear you say earlier that the judge, somewhere in this record, the judge acknowledged that the argument was preserved? We're going to see that somewhere in this record?
Yes, I apologize. I don't have that at my fingertips. I made the objection for the verdict slip, and I will provide the exact citation to the court via supplement if permitted.
Counsel, if we may, I'd like to go back to the question of duty for a moment.
Yes.
Let's say, change the facts a bit, where Draper had hired or used its own employees together with MB Construction, working side by side to clear the roof. And under that hypothetical, would Draper, I assume, have duties of care, including the responsibility to comply with OSHA regulations with regard to its own employees?
It would certainly be a closer question, but it would be determined by supervision and control. In that scenario, if it's a mixture of Draper and MB Construction employees, I think the factual question would be who was supervising them, who was controlling the manner in which they worked, and who had control over the work site on which they worked. So yes.
Well, assuming arguendo that it had a duty as to its employees, if an MV construction employee was injured because of Draper's failure to fulfill its duty of care, could the OSHA standards have come in under that scenario?
Potentially, if it's a scenario of joint supervision and/or control, yes.
Okay, and how do you address your brother's argument that given the nature of this roof and the fact that MV construction was, as a practical matter, prevented from implementing safety measures, and that it required long-term planning, that was it within Draper's control, that it's fair and meet to put that duty on Draper?
I actually would refer you to Lyon v. Morphew, because I think that's really the case squarely on point that addresses this issue. And I actually have a quote from Lyon v. Morphew. The SJC has never recognized a common law duty of building owners to place or maintain fall protection safety devices on roofs. That's 424 Mass 828 at 834. That's really what we're getting at.
But isn't there potentially a distinction between maintaining safety equipment on a roof and constructing and maintaining a roof on which standard safety equipment cannot be used?
No, because that's outside the knowledge of a building owner. That you're talking about specialized roofing industry details. If MV Construction had come back to Draper and said, we can't use our typical safety equipment, we need to bring in lifts in order to do this work safely, and Draper had said, no, I don't want you to use lifts, go do it anyway, that would be a different scenario. That would be where Draper is controlling the means and methods of the work. That's not what we have here. MV Construction at no point communicated to Draper that they couldn't use typical methods, that what fall protection equipment they were going to use, how they were going to use the job safely. This is a situation where if there was a spill on a cafeteria floor and that cafeteria hired a vendor to clean up that spill, and then he slipped in the spill, he can't then sue them for identifying a condition and asking them to remediate it. So I see that my time has expired. I'm happy to answer any other questions that the panel has.
Let me see. I don't see any, so thank you. Thank you both for your able and helpful argument. We appreciate.
And we are back live and on the record.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this format, all the ordinary rules of oral argument apply, including that each side receives 15 minutes per argument. With that, I'm going to call the case of Julie Norris versus Witten Norris, case number 2020P0984. And Mr. Norris, we are ready whenever you are.
Thank you, Your Honor. May it please this honorable court, I'm the appellant in this appeal, despite the fact that I prevailed on all the proper issues that were presented to the trial court below. Namely, I sought declaratory relief to have my child support obligation declared at an end. The court did so. My ex-wife sought to have me held in contempt. The court declined to issue any relief in that regard. Nevertheless, I'm here today because the court then went beyond the scope of the pleadings and the issues that were presented to it and issued a post-minority support order in favor of the mother without benefit of jurisdictional due process or procedural due process.
Counsel, can I just stop you there? The judge cited, as you know, to the Feinberg case. And speaking only for myself, I see this as sort of coming down to two issues. One is, did Feinberg provide a theoretical justification for doing what the judge did? And then two, did the judge go through the proper analysis and procedure and findings to use the, if you will, the authority recognized in Feinberg. And if the answer to the first question is yes, the Feinberg did provide the authority, then isn't this case really about, did the judge do what's necessary to invoke Feinberg? And if not, we need to send the case back for that analysis. And I would just add one final point, which is, in such a scenario, do you understand that you could end up paying more than you had agreed to the first time around?
The answer to your first question is yes, Feinberg does create that opportunity. I've never denied it. I've never disputed it. The answer to your second question is no, because there's no jurisdictional basis for the court to act at the moment. My ex-wife.
What do you mean by jurisdictional basis? Is it because your former wife didn't file a complaint?
Correct.
Seek relief on that basis? Okay, but your complaint put the issue of continuing post-majority child support payments before the judge. And why did she need to file a separate complaint as opposed to raising this as Feinberg issue as sort of a defense to your complaint for modification?
Because that issue wasn't joined, Your Honor. Child support under section chapter 208 is very different from equitable relief under chapter 215, section 6. The evidence required may be entirely different. There are no child support guidelines that the court can follow for post-minority support. This is just...
Ms. Minority, that may all be true, but as a matter of jurisdiction, this judge had jurisdiction under both regimes, correct?
No, I don't believe you can invoke a statute without at least setting forth a factual basis for invoking that statute. As we sit here today, I have no idea what legal theories or factual theories support the award that was made. In fact,
all right, in your supplemental memorandum in support of summary judgment, it looked to me like it was clear that that you knew that that section 6 was at issue, and that the court was considering that was at play.
At the time, I said that the issue was not properly joined because it wasn't right, because nothing had been asserted. I had no response to any factual assertions that I could make. I couldn't disagree with, and in fact, the judge picked a number that frankly is quite arbitrary. Even you sitting here today don't know why the judge chose that number. He simply continued a support obligation at the same level as had been agreed upon 9 years earlier. I don't know how to respond other than to point out that in my supplemental memorandum, I simply stated that, yes, that issue is always there when you have a disabled child, but the facts are different for one child than they are for 3. The circumstances of the parties are different than they were 9 years ago, financially and otherwise. My ex-wife has remarried. She remarried long ago.
So Feinberg says that it would put form over substance to require there to be a separate action commenced with stating the correct basis for jurisdiction, which here would be the general equity statute, right? But I understand you now to be arguing something a little different, which is you're saying that you weren't given the opportunity to develop facts relevant to the judge's exercise of that jurisdiction?
Correct, Your Honor. In Feinberg, the court, the child was in state custody, not in custody of the mother. And second, the mother was seeking funds for clothing and toys related to schooling. and the court sent it back to judge the reasonableness of those expenses. Those were expenses that everybody knew about. She'd filed a complaint alleging those expenses, and then the question was, were those reasonable expenses or not? The court sent that, in that case, sent the case back because everybody knew what was at issue. They were simply trying to determine the reasonableness.
She never offered any evidence of what the child's needs were once the guardianship was implemented.
Correct, Madam Justice. We agreed to the support amounts back in 2012.
That was for 2 children, is that right?
That was for 2 children who were both minors. And I paid that amount. The issue here, and again, this is not a dispute about whether or not the court has the equitable power to impose on me a support obligation, but it's not a child support obligation under Chapter 208. It's an equitable theory. Equity is based on facts.
All right, so I hear your argument is slightly different now than maybe I understood it from your brief, which is that it's not really a matter of the court's competence when you're talking about jurisdiction, that the court didn't have competence to act on a Chapter 215, Section 6 kind of equitable post-majority support order, but rather that the facts did not justify the order here. Is that correct?
That is correct.
Okay, then let me ask you a question then, now that I have that straightened out. This was a trial by representation that the parties agreed to proceed in that format, which is not unusual in the probate court. And we don't have the trial transcript. So how can we possibly assess the arguments that you are making about the correctness or incorrectness of the amount of the support award?
Well, first, Your Honor, I can't prove you're correct. I didn't order the transcript because financially I wasn't able to, but more importantly, there was no trial. It was a summary judgment hearing. The judge, I don't know what proceeding by representation actually means, even though I practiced law for many, many years. It's a new one by me, but that's really not my point. My point is that if the court is going to impose a support obligation on anyone based upon Chapter 215, Section 6, it's not up to me to provide the factual support. It's up to the court to reference it and make its determination based on those facts. There are no facts.
How do we know that without the transcript? When you tell us there are no facts, how do we know that without the transcript?
You know that by looking at his decision. His decision cited 3 facts. 1, the mother was the guardian of the son. 2, he was incapacitated or an incapacitated person. And 3, I had the financial wherewithal to pay the money.
And none of those has been shown to be clearly erroneous.
Because those 3 facts in and of themselves should never justify an award of the amount that we're talking about here. It's a continuation of a pre-existing obligation. It's not, there's no express justification for imposing it at all. It's something that's 9 years old that was based upon a point in time when I was still practicing law and making much more money than a 65-year-old retiree.
So in your view, would the solution be for us to ask the judge for additional findings with respect to the amount?
No, Madam Justice, I don't know. My ex-wife is remarried. She lives in a house with her husband. It's her husband's home. As far as I know, based on her financial reports, she has few, if any, expenses. I don't know what her ability to support our son is any more than she knows what my ability to support our son is. I don't think the court knows what that ability is. The court simply said, I'm going to rely upon what I found 5 years ago and continue to impose that on you. The court made reference to evidence that was never introduced by either party. Now, you're right, because you don't have a transcript, you can't determine that, but there is no exhibit pile that was designated by the court because there were no exhibits. They would be part of the record if there were. So the references to
It
documents.
would only be part of the record if you put them in the record. We only know what you put in the record.
But the record appendix was prepared by the court.
No, the record appendix is prepared by the appellant.
Well, I'm sorry. If you look at the docket, there are no exhibits. There never were. I couldn't designate that which doesn't exist, but the court references in the decision things that I never saw. I don't know what DOR report he was referring to because he didn't present it and it wasn't introduced by either of the litigants. So I don't know how to designate it as something as part of the record, which was never before me. The hearing report that he talks about was never specified. I don't know which hearing report he's looking at. So you're asking me to, or placing a burden on me to do something which wasn't done by the judge. He made reference to it in his decision, but I only saw the decision after
So
the
the
hearing.
remedy would be a remand for a hearing, an evidentiary hearing?
I don't really know how to answer that. I've been paying for 3.5 years the amount that I've been ordered to pay. As far as I know, whether that's more or less, and I think Justice Milkey was correct, I'm at risk. I don't know what I'm going to wind up the outcome being, but all I know is that the order as constructed was done without due process, and it was done without a proper jurisdictional basis, because if there's no complaint, in fact, when I was paying child support, if I wanted to get a modification, I had to file a complaint for a modification. Otherwise, even if I were overpaying, without the complaint, the court can't make a retroactive modification. I was always told that that's the rule, and I've looked it up. I can't cite you chapter and verse now, but that's the law. Well, without a complaint seeking post-minority support, how does the court make a ruling that dates back to some date that I knew nothing about it? When this judgment was issued, I was immediately $12,000 in arrears simply because he backdated it for a year. And how do you apply to get reinstated when you're perpetually in arrears because the judge started you a year behind the 8 ball, and you're not practicing law, and you're unable to, meet the requirements to get out of debt? That's the constitutional problem here of just remanding it. He gets to start all over, but I'm still saddled with all of that debt.
But counsel, in terms of the absence of the transcript, the other potential problem there is we don't know the extent to which the objections you're now raising were preserved. Because, I was just looking at the order of the court, and I have to wonder if the Feinberg issues came out of the blue as much as you now suggest. So, to the extent they were discussed at the hearing, it obviously matters whether or not you made the arguments you're making now at that time.
The court raised the Feinberg issues and and it's in my it was in my supplemental memorandum. The court invited us to respond to those cases sua sponte. We were given extra time because we didn't have prior notice prior to that hearing. So I was not able to respond. I hadn't read those cases. The court asked us whether they were applicable. And so I filed my supplemental memorandum. I believe in that supplemental memorandum, I accurately represented what happened at the hearing. And I gave my views on the application of those cases to the issues as they were presented at that time. And I believe from my memory that I claimed that those issues were not right. They weren't, because no complaint had been filed. I had no idea what the legal claims were or what factual issues were being asserted as a basis for further support obligation. It's just, I guess I've always felt that child support under Chapter 208 is very different from post-minority support under Chapter 215. They're two different things. Chapter 208 is highly regulated, has child support guidelines. It has all kinds of fabulous mechanisms for helping the court determine what is the appropriate support obligation to minimize the burden on the court.
Mr. Norris, so just one more question. So we would, though, have to remand because you're challenging the amount of the arrears. And my understanding of how the judge reached that figure was that part of it was based on backdating it to the date of the guardianship, which was January 2017, but then part of it preceded that date. Isn't that right? So we would have to remand for recalculation of that amount. Were we to agree with your arguments?
While the trial judge did not articulate it, I will represent to you that my own mathematics tells me that if you take the amount of the arrears as determined by his decision in 2015, which I didn't dispute or challenge, and you take his judgment that 2 months later, my child support obligation ended on February 15, 2015. If you add those two numbers together, you'll get to the amount, the total amount of the pre-emancipation arrears. And he did say that I made efforts, and he didn't quantify it, but I made payments to try and reduce that arrears. The retroactive award of post-minority support reduces my
but
arrears payment.
but your challenge is not limited to just that, right? I understood your argument to be you're challenging both the retroactive award to January 2017, but you're also challenging something that the judge did in calculating the arrears prior to that date.
No, I am not challenging the arrears prior to that date. Those were fixed back in January 2000.
You said that you had made some payments between February 2015 and January 2017. And I took your argument to be that you should have been, those payments should have been offset. The arrears should have been offset by those payments.
And the judge said that they should be as well. The problem is that he imposed a new obligation. And so the numbers build on each other, and he never calculated it. I simply say, if you eliminate the new obligation, which was never properly presented by way of complaint, that he just pulled out of thin air, the numbers become very different. My contention was that I paid off my arrears in September of 2018. But that presumes that the court vacates the post-minority award. If the court doesn't, or if we go back on a remand and start all over again, I'm still under an obligation to pay $1,000 a month, whether it's the proper amount or not. I don't know. So.
All right, I think we have your argument. Let me see if there are any other questions. All right, thank you very much. We have your argument and your